pretty straightforward. There's a statute right in the discovery statutes which accepts law enforcement investigation, which I failed to cite to the court last week, that I believe is dispositive along with the recent second district case. I don't think it'll take the court forever to decide this, frankly.
All right. It looks to me, because of some of the medical appointments that we will have to make adjustments for, we will have room on our calendar in our court day to take these up. But let me see how long we run with this shield law business.
Okay, great.
Before we make that determination. All right. Dean Allman, you want to go first on this?
Yes, Your Honor. We would like to
We actually have a number of sub-issues here. I note that we have a motion to quash a subpoena ducis tecum. We have a motion to quash a subpoena on Tracy Savage, and we have a number of other sub-issues in that category. So how do you suggest we proceed, first of all?
Well, we suggest calling Tracy Savage to the witness stand to see if she declines to reveal the source, and we will then proceed with a showing of why the qualified privilege should be overcome in this case. Privilege is a misnomer. Why the assertion of immunity should be overcome in this case.
All right.
I don't believe the assertion of the immunity is grounds to quash the subpoena, but if Your Honor wishes to hear argument on the motion to quash the subpoena before we put Ms. Savage on the stand.
I think that's what it comes first, logically.
All right.
All right. Let me ask, who's going to represent the people on this matter?
I will, Your Honor.
All right. Do you have any position regarding the motions to quash the subpoenas on KMBC, the subpoena DT, and the motion to quash the subpoena on Tracy Savage?
Well, Your Honor, we don't have a position per se as to some of the issues because they involve policy concerns that don't directly involve the people. However, one of the prongs of the three-prong test that the court would rule under Delaney versus Superior Court has to do with the materiality of the evidence, and obviously we have a very strong interest in how Your Honor would rule on that, because ultimately it would affect the court's decision if there was any information that resulted from these inquiries. It would affect whether or not Your Honor was going to...
If I deny the motions to quash the subpoenas.
If you deny the motions, that's right. But there's a question here as to placing the cart before the horse, because it seems to me that this is a primary threshold issue that the court would have to concern itself with prior to making the decision as to whether or not it was going to quash the subpoena.
All right. Ms. Edgerton.
Good morning, Your Honor.
Good morning, counsel. Do you want to approach and make your appearance for the record? I guess the ball is in your court then, because what I'll entertain at this point is a motion to quash the subpoenas, both the SDT and the subpoena for Tracy Savage.
Your Honor, Kelly Sager is going to address the motion to quash with respect to Ms. Savage. As the court knows, our motion on the SDT is basically just a sort of tag along on that, which I would be happy to address after Ms. Sager has argued.
All right.
Thank you.
Good morning, Your Honor.
Good morning, Ms. Sager.
Kelly Sager, appearing on behalf of Tracy Savage, was a reporter for KNBC Television. As the court has indicated already on the record, with me today are Ann Edgerton and Patricia Duncan, who are in-house counsel for KNBC. And we have filed a motion that I understand the court has received and reviewed to quash the subpoenas directed to Ms. Savage on two grounds. That, as we understand it, the only two things that the defense is seeking from Ms. Savage are to reveal her confidential sources, which we think is protected under the First Amendment, the California Constitution, the California Evidence Code, and to the extent that they're seeking to have her authenticate tapes that were broadcast by KNBC, that she is not the appropriate person to do that, that a custodial declaration or a custodian of records who actually keeps the broadcast footage would be a more appropriate person to testify. So neither of the two things which the defense seeks to have Ms. Savage testify about are appropriate, and that's why the subpoena should be quashed. If I could just start with a premise that in California, the shield law protecting reporters from having to reveal confidential sources has existed, at least in statutory form, for more than 60 years. And 15 years ago, the California voters elevated that provision to a constitutional provision. And California courts have recognized that by doing so, the voters intended, as the legislature had previously indicated, to indicate that this was a very important principle under California law, and in fact that it was to be given the highest possible protection, which becomes important when the defense attempts to compare the California shield law protections to other protections that are given statutory protection. The leading case, it's clear, is Delaney versus Superior Court, which, although the circumstances there were very, very different from the circumstances in this case, at least laid out factors that the court is to consider in making a determination in a case involving a criminal defendant who's attempting to seek information from a reporter. And Mr. Goldberg indicated correctly, there is a threshold issue that the court must reach before it engages in any kind of balancing equation. The defendant has the burden of proving that there is a reasonable possibility that the information that they are seeking will materially assist the defendant in his case. And if this threshold inquiry is not met, the court's inquiry stops. It need not reach any of the other factors or engage in any balancing analysis. And the language is important, although the defense has suggested that this is an easy threshold to meet. In fact, it is not. It must be a reasonable possibility first, not merely any possibility that the information will assist the defendant. And the Delaney court specifically said it must go beyond mere speculation or conjecture or some hypothesis about how this information might affect the defendant's case. That goes to the likelihood of the information being useful. But there's a second prong. It must materially assist the defendant's case. So it must be significant information to the defendant's case, not merely any information that has a potential of affecting their defense. And if you even look in a dictionary, Webster's defines material as, quote, having real importance or great consequence. So even if the Delaney court indicated the information doesn't necessarily need to exonerate the criminal defendant, it has to be something more than merely tangential or peripheral information. It implies some sort of direct proof of an important issue in the case. Neither of these two parts are met in this case, let alone both of them. It certainly, as I understand the defense's theory, this information is sought simply for the purpose of establishing some possibility that there might have been some conspiracy to frame the defendant with respect to the planting of blood on the socks found in Mr. Simpson's bedroom. The identity of the sources of a KNBC News report broadcast in September is certainly not direct evidence of any conspiracy. And in fact, as Mr. Goldberg argued, I thought quite persuasively last Thursday, it's counterintuitive that someone who is engaging in a conspiracy would run out and the first thing they do before the conspiracy has even been effected is tell a reporter, oh, here's what we've done. Why reveal that information for public dissemination on a date when the testing simply had not been done, if that in fact is the case? It's counterintuitive that someone engaged in a conspiracy or who knew about the conspiracy would have done that. But moreover, it's not even indirect evidence of a conspiracy. And the defendant's argument here is incredibly attenuated, that someone who was involved in some kind of conspiracy would have told a news reporter about tests so that they would know that the tests, which had not yet been conducted, according to the evidence presented in court, were going to reveal something that had not yet occurred. Any other explanation for how this information came to Ms. Savage is far more reasonable than the attenuated link of factor upon hypothesis upon speculation that the defense would like to use it for. The sources may well, as Mr. Goldberg suggested, have simply mistook the PGM subtype testing for DNA testing, which, as Mr. Goldberg indicated, does have an element of genetic markers, and someone revealing that information might have mistook that to mean genetic testing as in DNA testing, as opposed to the PGA subtype testing. Or they simply may have extrapolated what they knew was going to occur, DNA testing, with the information that had already been proven, the PGA subtype information, and extrapolated that out to likely DNA test results. Those explanations are far more reasonable than what the defense would suggest. And in order to meet the standard of reasonable probability of materially affecting the defense, I think they have to show something more than that. And it's important or instructive that even the defendants themselves, the defense counsel, up until the time where this court indicated that Ms. Savage would have to take the stand, have never taken the position that the sources are important, let alone critical or go to the heart of their claim. And Mr. Ullman repeatedly advised the court on Thursday that defense counsel does not believe that it needs to know precisely who the sources are of this information in order to establish their case. Given that, and given that it certainly is not direct evidence or even arguably reasonable indirect evidence of what the defense is, I think that they haven't met the threshold showing that the Delaney court established. But even assuming that the court found the threshold test had been met, which we do not believe it has been, then the court must go beyond that and look to the factors that the Delaney court identified and balance those factors and consider those factors before requiring the reporter to take the stand. There were 4 identified in the Delaney opinion, and we would submit that all 4 argue in favor of quashing the subpoena. The first is whether the information is confidential or sensitive. And the Delaney court recognized that on a sliding scale, when you're weighing a criminal defendant's Sixth Amendment rights, that non-confidential information may be at the bottom end of that scale, although they made a point to say that even in that case it may be protected. Sensitive information, which is not confidential, may be subject to greater protection, but the highest level of protection under the Shield Law is given to confidential source information, which was not at stake in the Delaney case, yet they took great pains to indicate that that is a distinguishing factor from the circumstances that were before the court in that case. Here the sources are confidential, and this factor heavily weighs in favor of quashing the subpoena and not forcing Ms. Savage to testify. I'd point out that the defense counsel did file a brief, although I think by error this was not filed with our office, but simply served on NBC's counsel, but I did have an opportunity to read it late last night. And they've misconstrued this factor as somehow being dependent on what the information is being used for. And they refer to a quote in the Delaney case about information being used to show corruption in government. But that was related to a different factor entirely. The Delaney court indicated that the first factor to be considered is whether it is confidential. And if it is confidential, that is an important factor weighing against forcing a reporter to testify. In the example of corruption in government, the Delaney court was referring to sensitive information that may not be confidential, but nonetheless should be subject to some kind of protection. The second factor the Delaney court recognized was what the interests are that are sought to be protected by the Shield Law, and whether the interest is mooted by something, for example, like the defendant himself being the source of information. And there's no showing in this case by the defense camp, who certainly would be aware of that if that were the case, that the defendant himself is the source of information. And that has been the case in other cases considering confidential source information, where reporters have gotten information from the defense or from defense counsel, and the defendant or his counsel have then tried to get the reporter to confirm what they had told earlier to the reporter. And under those circumstances, the Delaney court said that may be a different kettle of fish entirely. But that's not the case here. The defendants are not arguing that they need Ms. Savage to confirm information that they provided to her or something that Mr. Simpson provided to her. The policy of the Shield Law is clear. It is to promote news gathering and dissemination of information to the public. And in both the Delaney court and a variety of other decisions in California and elsewhere, courts have recognized that it is critical to protect a reporter's confidential sources, and that policy, that important protection, should only be overcome in a very rare circumstance. So the second factor also militates in favor of a motion to quash the subpoena and against forcing Ms. Savage to take the stand. The third factor is the importance of the information to the defendant. The Delaney court indicated that even once the threshold is met, if the information is so critical to the defendant's case that he cannot have a fair trial without this information, then that may weigh even more in balance of the criminal defendant. But that's not the case here either. We don't even think the threshold has been met, let alone something that so materially would affect the defendant's case that he cannot have a fair trial if this information isn't provided. This is not an instance, as has been true in some other cases involving confidential sources, where the reporter is protecting someone who is an eyewitness to the crime, who could provide information that goes directly to guilt or innocence. This is so far removed from that, as Mr. Goldberg indicated in his argument last week, that this is 15 steps down the road from anything that would go directly to Mr. Simpson's guilt or innocence. The final factor the Delaney court indicated the court must weigh is whether there are any alternative sources for the information. And even though they did point out that this should not be rigidly applied, the Delaney court made clear that where, as in this case, the information involves the identity of confidential sources, that this requirement should be more vigorously imposed. And in the Delaney case, there were no confidential sources involved. It was a reporter's eyewitness observations. And so in that instance, they said that this factor does not weigh as heavily as it might in a case that involves confidential sources. This case does involve confidential sources. So this factor becomes even more important. And there has been no effort whatsoever by the defense to examine any witness on the stand about whether they were a source of information for Ms. Savage, to call any witnesses to the stand, to try to narrow the scope of people who might have been potential sources. The defense counsel argued last week that there are a limited number of people that this could possibly include. And yet they've made no effort to examine any of those people to determine whether they were the possible sources. So of the 4 factors in this case, all 4, we would submit, argue in favor of the motion to quash. And completely distinguishable from the result in Delaney, in this case, this is not a reporter's eyewitness observations. Confidential source information is involved here. It is a case where it does not go directly to guilt or innocence, whereas as in the Delaney case, the reporter was had been an observer of whether or not the defendant had given consent to a search. And if the consent had not been given, everyone agreed that the search would have been improper and only the search had led to the defendant's arrest. So there it directly went to the issue of whether the defendant was properly arrested or not. The final point that I would mention is that the defendant has submitted in their papers that he is somehow entitled to this information in order to present his defense, and that if he's not given this information, that his fair trial rights are interfered with. And they cite a number of cases where, depending on the circumstances, depending on the importance of the information, there has been some overcoming of a particular asserted privilege. But in both California and other contexts, in the Reporter's Shield Law, California courts have consistently held the fact that there's some information that the defendant cannot get, for whatever reason, either because of a statutory exemption, either because of a California constitutional provision, as is at issue here, because of evidence code provisions like 352, like the hearsay provisions that say there is some public policy reason why the defendant is not entitled to put this evidence on. His fair trial rights are not interfered with. And we can certainly cite to the court innumerable cases involving various privileges, involving various protections, statutory protections, and statutory policy decisions where courts have said the fair trial rights are not implicated simply because the defendant cannot get what information is he is seeking. But even to the extent that the court accepts the defendant's argument that he needs to be able to present an argument to the jury that the fact that Tracy Savage had a report in September of 1994 about socks, which had not yet been tested by DNA testing, that they argue this somehow furthers their conspiracy claim. They can make that argument to the jury, present the videotape, and make that argument without delving into Ms. Savage's sources for the information. They can argue that if they're knowledgeable sources, then that furthers their conspiracy theory, and the prosecution can argue that it does not.
When we talk about alternative sources for the same information, can you think of a plausible justification that I would allow a TV news broadcast to be played to the jury as evidence?
Well, Your Honor, in our personal view, my personal view, I don't think that the television broadcast is probative of any issue in this case. So I don't think there is a reason for the court to present the video to the court.
Let's try with something more fundamental like hearsay. I mean, how would that ever be overcome?
I'm not advocating that position, Your Honor, because I don't think that it is probative or that it does overcome all the objections.
Well, no, you offered that as an alternative source.
That if the court believes the defense argument and believes that they've overcome these objections and believes or agrees with them that this is probative or material information, then that's a separate issue entirely from whether the sources of that information are probative or material or relevant. In other words, the argument that they make, whether this somehow furthers some conspiracy, even if you assume everything that they say, and assume that this is material and important and that it did come from some high-ranking official somewhere, if you assume all of those things, then that's the source of the particular individual becomes irrelevant. But I agree with the court. I don't think it is probative of any issue. I don't think it's material to Mr. Simpson's defense, and I think it would simply serve to confuse the jury on a tangential issue and distract the court's attention by focusing on a whole panoply of witnesses and evidence and issues related to who Ms. Savage's sources were for this story instead of the material issues in this case. And I'm not aware of any case where a reporter has been forced to reveal confidential sources about an article which both sides have acknowledged, or at least the parties admit, was inaccurate as to the point that they say is important. So all the cases where a reporter has been forced to reveal confidential sources, and they are few and far between relative to the number of times that information is sought. But even in those few cases, there's no case that I'm aware of that even remotely is close to the circumstances in this case. And given the critical, I think the Playboy Enterprises case uses the word paramount, interests that the voters of California expressed in enacting this into the Constitution, given that paramount interest, it's a very high standard that must be met. And I don't think that the defense in this case has satisfied even the threshold, let alone any of the four factors that argue against forcing Ms. Savage to take the stand.
Thank you, counsel.
Thank you.
Mr. Ullman?
I think we're in agreement, Your Honor, that the guide for the court's decision in this matter is the Delaney opinion, and I think that opinion sets forth a very clear blueprint for the court to follow in addressing the issues that are presented. Number one, Delaney makes quite clear that we are not dealing here with a privilege, that we are dealing here with a immunity from contempt, and that immunity is a qualified immunity. So the existence of the newsperson's shield law presents no basis to quash the subpoena. In fact, Delaney indicates that the reporter initially bears the burden of proving that the shield law even applies. And I don't know that we're to that point yet. Ms. Sager assumes that, for example, the source in this case is confidential. We don't know that. We don't know what assurances or promises were given to the source in exchange for the information. It may have been that no such assurances were made and no promise of confidentiality was made to the source. The other thing that Delaney makes quite clear is that the shield law does not protect information that has been disseminated. And in that respect, all of what KNBC has already told us about their source points very clearly to a strong possibility that the source came from within the Los Angeles Police Department. And that, of course, is the important fact that the defendant is seeking to establish. The qualified immunity can be overcome by the defendant's right to a fair trial. And Delaney indicates that all the defendant has to show is a reasonable possibility that information will materially assist the defense. We believe that in the current juncture of the case, we already have enough information before the court to suggest a reasonable possibility that this information will materially assist the defense. Because we already know, for example, that the broadcast of this information on September 21st coincided with activity within the Los Angeles Police Department that would only be known to sources within the LAPD. That on September 18th, a PGM subtype test had been performed, that preliminary results had been obtained, and that apparently on September 21st, a decision was made to send the socks out for DNA testing. We also know that just 9 days before, cell mark test results were leaked on the same day that they arrived in a fax to the LAPD SID laboratory. Your Honor is also aware that as soon as Your Honor entered an order requiring that all test results be sent directly to the court, the leaks stopped. As soon as they stopped going through the sieve of the Los Angeles Police Department, the problem of leaking came to an end. We also know, and this is pointed out in Ms. Sager's moving papers, and I thank her for that, that other news media apparently who were reporting similar stories, although not reporting the false information that KNBC reported, identified law enforcement as their sources for this story. So all of these factors and KNBC's own revelations thus far about their sources point to the Los Angeles Police Department. Now, if in fact this leak came from the Los Angeles Police Department, there will be a strong inference to support the defendant's defense of evidence tampering in this case. First of all, we have within the Los Angeles Police Department sources confidently predicting results of tests that have not even been performed, suggesting that that confidence may have come from knowledge of the source of the blood that was being tested that would emanate directly from participation in the tampering or planting of that evidence. We also have a very strong motive to predetermine the test results. We also have very strong evidence that this investigation lacked objectivity. Time and time again, we've been treated to the prosecutors getting up and asking police witnesses, "You're not part of any conspiracy in this case, are you?" Well, what we have here is very strong evidence of a conspiracy to prejudice the defendant's rights to fair trial by leaking information during the pretrial stage at the very time that we were engaged in the process of selecting a jury in this case. And what more compelling kind of conspiracy could you have? And finally, if you put this all in the context of the SOX, that we are talking here about the leak of information related to the SOX in a context where we have already established discrepancies in the collection of that evidence in terms of the reported time that the SOX were recovered, discrepancies in the observation of blood, in which we were told that numerous criminalists did not see blood on the SOX until 6 weeks after the SOX had been collected, evidence of experts that the blood pattern on the SOX do not conform to blood splatter, but to the actual compression of blood against the sock, and testimony of experts that the blood stains contained EDTA that the sock itself did not contain. Now, all of that weaves an important web of evidence with respect to the integrity of the evidence collecting process and the possibility of tampering with that evidence. Putting direct evidence that the source of this news report came from the Los Angeles Police Department would not just present a reasonable possibility of materially assisting the defense. It would indeed go to the heart of the defense. And we believe that that provides a very compelling argument to overcome the assertion of the qualified immunity in this case. With respect to the balancing test that the Delaney court set forth, there are 4 factors, as Your Honor is aware. The first relates to the confidentiality or sensitivity of the information. We have yet to hear any evidence that the reporter has the...
Well, Mr. Ullman, let me ask you this then. Following your argument to its logical conclusion, assuming that I deny the motions to quash the subpoenas for Tracy Savage, she testifies, says I gave some assurance of confidentiality, and I now refuse to divulge those sources, and I claim immunity from the contempt sanction. Mm-hmm. Let's assume that I make a further finding that I find the information to be material and necessary to Mr. Simpson's defense, and I invoke the contempt sanction. And let's further assume that I grant a temporary stay of that contempt citation so that Ms. Sager can run down the street to the Court of Appeal. and file her emergency writ. And let's assume that Justice Turner has nothing else to do that day and has the opportunity to spend an enormous amount of time dealing with the issue. Let's assume all of that occurs. Is that really necessary? Because all you're really asking for is the opportunity to present to the jury that at the relevant point in time, this misinformation was reported.
Well, we're entitled to do more than that. I think we're entitled to do that. We're certainly entitled to present the misinformation that was reported, to present the explanation of the information that has already been publicly disseminated, which points to the Los Angeles Police Department. We're entitled to present the director of the LAPD laboratory to describe what was going on in terms of protecting this information, and then argue to the jury an inference that there is tampering going on and that this information came from the Los Angeles Police Department. But what Ms. Savage's testimony would do for us would be to present direct evidence that it did indeed come from the Los Angeles Police Department, so we no longer have to rely on an inference. Because you can bet that the prosecution will argue against that inference. They will say, that's not a fair inference to draw from this evidence, as we heard last Thursday. It could have been a lucky guess. It could have been that they were relying on some interloper or some flake to present this information to the public. So we'll hear that argument. But by cutting through the assertion of qualified immunity, we don't have to rely on an inference. We can present direct evidence that indeed this information did come from the Los Angeles Police Department, which is very compelling evidence that goes to the heart of our case.
I think the strongest point that you make inferentially is that once the court ordered all test results be directed directly to the court rather than to the investigating agencies, that all of this nonsense stopped.
I think when we talk about, balancing the public interest in this case, I think that's very important to bear in mind, that we are not talking about the access of public to information that would never otherwise be disclosed. All that we're talking about here is the interest of a court in preserving the right of the defendant to a fair trial until a jury has been selected. And what was going on here was a very deliberate attempt to subvert that process simply by giving the media advance information at the time when it would prejudice the defendant's rights. We're not talking about information that would never be disclosed. In fact, this information has now been disclosed in this courtroom in the orderly process of law, which is when it's supposed to be disclosed. So all we're talking about here is some news agency somehow getting an edge so that they have an exclusive that can severely prejudice the right of the defendant to get a fair trial, to get jurors who have not been prejudiced by information that the court has a right to control, to prevent its dissemination until the time is appropriate. There's one other aspect with respect to this matter with regard to alternative sources, and that is we are informed, although we have never been provided with any of the results, that an internal investigation was conducted by the Los Angeles Police Department. So there was an alternative pursued to attempt to identify the source within the LAPD by an internal investigation. If the results of that investigation have been turned over to the prosecution or to the court, they have not been turned over to the defense, and we think that information may be relevant and helpful to the court in resolving the issues that are presented by this motion today.
All right. Thank you, counsel. Mr. Goldberg, do you want to address any of the materiality argument raised?
Yes, Your Honor, that is the only issue that I did want to address. Because, as I said, I don't think that the people have a direct interest in the balancing part of this equation. But let me just say this, that in addition to the threshold standard that's articulated in Delaney, requiring that the defense show a reasonable possibility that the information will materially assist his defense, that's at page 808, that there is an independent legal theory to look at this issue of quashing the subpoena, and that is that you always are going to have to show, in an instance where a motion to quash has been made, that the witness in question has some material evidence to give, because we don't allow people to run around subpoenaing individuals that do not have any material information to provide in a given case. So independent of the legal theory that's articulated in Delaney, the court would always have to look at the issue of relevancy and materiality of a witness in determining an issue to quash. But the two obviously are very closely interconnected, the standard of relevancy and also the Delaney standard involving materiality. On page 6 of the defendant's points and authorities, they articulate what I think we can characterize as somewhat of a laundry list as to possible relevant purposes or material purposes for this kind of evidence, and I'd like to go through them. I've addressed some of this previously on Thursday, and I'll try not to repeat what I said to Your Honor at that time. On the second full paragraph starting at line 13, they say that for persons who are directly engaged in the handling of evidence, to leak the results of tests before the testing has been completed creates a strong inference of illicit tampering with the evidence. So that's one theory. It's the tampering theory. I'd suggest it's really the only theory that should be under consideration by the court at all. But what I would point out about the way that the defense articulated this is they themselves have pointed out that the only conceivable way that this could be relevant or material is if someone who was actually involved in the testing, according to the way that they phrased it, was responsible for the leak. Because obviously if we had a situation where it was someone at robbery homicide who overheard a conversation, or someone in the prosecutor's office, there's no conceivable way we can even articulate a theory under which that leak would be relevant, and I think the defense acknowledges this. So the issue then becomes, Your Honor, if someone who was directly involved in the testing themselves was in fact the individual who was responsible, if there was an individual, for the alleged leak, how is that relevant, or is that at all relevant for the purposes of this threshold requirement that the defense must make? And we say that it isn't. On Thursday, I articulated two different ways that the defense could contend that this is relevant. One, they could suggest that the news report motivated the individual that tested the evidence to plant evidence. That is not the theory that they are articulating, and Mr. Ullman specifically rejected that as a theory. I think this is important to try to force the defense to be analytically precise in what their theory is, because in doing so, then we can determine whether there's any merit to it. So we can slowly begin to chip away at what they're not contending so that we can focus our attention on what they are contending. For example, on Thursday, I pointed out that the evidence that the defense claims shows that the socks were not present in a photograph that was taken supposedly before Mr. Fung collected them, that evidence was not relevant to the issue of planting. And Mr. Ullman conceded that that was true, and said that that only was relevant to the issue of whether or not the evidence was properly handled. In other words, that it went more to unintentional mishandling of the evidence, because it was not reasonable to conclude that blank socks themselves were planted and that subsequently evidence was planted on those socks. So I'm just trying to point out to the court that by trying to force the defense to articulate precisely and clearly what their theory is, only then can we then be in a position to determine whether or not that theory has sufficient probative strength and whether there's any evidence to support it for the purposes of this threshold requirement. So what their theory appears to be is that the fact that someone, or if someone who was connected with the testing of the evidence leaked evidence regarding the socks, that demonstrates or tends to demonstrate that evidence was planted on the socks prior to the time of that leak. And the reason that we say that that theory does not make sense and is illogical is because one cannot conclude reasonably that an individual that was responsible for testing these socks and knew that the evidence was planted, then decided to disclose that knowledge to the press. It is counterintuitive, as has been argued. And in fact, if such a leak did occur, that fact would tend to exonerate the individual, because the logical and reasonable argument would be, why on earth, if I in fact planted evidence on the socks, would I then do anything that might have the tendency of giving myself up, such as contacting the media and saying that there are test results that have been performed on these socks. It is not reasonable to believe that this individual would do that. It is not a logical and believable argument, and therefore the defense theory that this logically relates to the issue of planting should be rejected. Now, in addition to that particular theory, the defense has two additional, what I would characterize as throwaway type theories of relevance, perhaps seeing the weakness in the first theory. The second one is, they say, I'm quoting from the same page, page 6, that this evidence is, quote, direct evidence of examiner's bias, end quote. Well, the LAPD didn't do any of the DNA testing on this case, so there's no logical argument that this in any way relates to examiner bias, and they don't attempt to articulate how it does relate to that issue. And then thirdly, they contend that this is relevant to a rush to judgment. But I would state, Your Honor, that the issue of rush to judgment itself is not relevant, because the subjective beliefs of the law enforcement officials, the DAs that are involved, the deputy DAs that are involved in prosecuting this case, and the detectives that are involved in prosecuting this case, whether they subjectively believe the defendant is guilty, and if so, when they form that belief, is not a relevant issue. It never is in a criminal proceeding. And somehow this has been allowed to have been introduced and interjected in this trial as a spurious non-issue that has no real evidentiary significance. But even if it did, I don't see how this leak in any way relates to the issue of rush to judgment, or the non-issue of rush to judgment. So if we go through the defense contentions and we carefully look at them, it does not appear that there is any theory under which it would be relevant. And clearly there is no evidence to support any of those theories. And apparently they must produce at least some evidence, because according to Delaney, mere speculation itself is not sufficient to meet this initial threshold requirement. And therefore, Your Honor, we contend that the threshold requirement has not been met. Now, in addition to this issue, I'd like to address briefly the question of whether or not the report itself is hearsay, and I don't want to do that at length, because I think the court has already impliedly indicated through some of its comments that the news report itself is clearly inadmissible hearsay, although the court argues to the defense argues to the contrary.
Well, let's not get to that issue yet. We're not
Okay.
at that point.
All right. And finally, Your Honor, as to the issue of the internal investigation, the defense was aware of the internal investigation because it was mentioned on the record, and I believe even requested by defense counsel at the time that this issue was initially addressed by the court on September the 22nd and 23rd, where they suggested that an internal investigation should be conducted. We do not have the reports from such an investigation that I am aware of, and I do believe that they never did pinpoint what was the source of the leak, so there isn't any information that the people are aware of any value as a result of that investigation. If the defense wants those materials, then there is a way of getting materials, and they have to use the procedures that are required under a pitches type motion to get those kinds of internal LAPD documents, and they can file that kind of a motion if they want to. But in the absence of the procedures that are required under pitches, they are not entitled to that kind of information.
All right, thank you. Ms. Sager? Briefly.
I just want to respond briefly to a couple of points made by Mr. Ullman. First, with respect to whether a motion to quash is appropriate, he indicates that because it's not a privilege but an immunity from contempt, that somehow this is not the correct procedure for the court to adopt. But whereas here you're involving a non-party, contempt is the court's only remedy. And in that instance, the California Supreme Court has said, for example, in the New York Times versus Superior Court case, that it operates as an absolute privilege if contempt is the only remedy. So it operates in the same effect as a privilege, and a motion to quash is appropriate. And in fact, that is the way that most courts in California have reached this issue, through a motion to quash a subpoena or a motion to quash a seeking of testimony from a reporter. So I think the court certainly can use this procedure to rule on these issues, and we hope will accept the motion and quash a subpoena. He raised
What about Mr. Ullman's point that the record is devoid of any evidence, as opposed to proffers of counsel, that Ms. Savage is in fact a news reporter covered by this particular statute, that she is in fact the person who participated in the reporting that is in question, and that she gave some assurance of confidentiality to the sources of that information. Isn't the record completely devoid of that?
Well, Your Honor, I was about to reach that issue, and it certainly has been represented by counsel, and until this point in time, it wasn't, to our knowledge, there was any question about any of those things. And we would have been happy to submit, and still would be happy to submit, a declaration from Ms. Savage covering those points, indicating, as I think was indicated in our brief, that she is in fact a reporter for KNBC Television. She was acting in that capacity when these stories were broadcast, and that the information for those stories came from confidential sources, individuals to whom promises of confidentiality were made. And we would be happy to do that. I don't think it's appropriate to then conduct an inquiry into her other information in order to have that information before the court. We can have a declaration here before the end of the day that sets forth that information if there's any question about it. And to this point, there never had been, and at least at the hearing last fall when this issue came up, it was represented, and counsel all seemed to agree that that was the case, and that the issue was whether or not the privilege would be overcome. But we're happy to provide a declaration to the court containing that information. Now, Mr. Ullman suggests, I think mistakenly, that the only issue is whether this information materially assists the defendant, and as is clear in Delaney, that is only the threshold. And I agree with Mr. Goldberg, and based on the information argument I've previously presented, they have not come close to meeting that threshold test, let alone exceeding it. But even if they did exceed that threshold test, which I think they clearly have not, then the court looks to the 4 factors in a balancing equation. It simply doesn't say, okay, the reporter now takes the stand. We've determined that it materially impacts the defendant's case. And as to the 4 factors, there's been no showing that those factors militate in favor of forcing Ms. Savage to testify. And with all due respect to Mr. Ullman, most of what he presents is irrelevant to that issue. What other media reported has nothing to do with what Ms. Savage's story was about or who her sources are. Whether or not there's other evidence of a conspiracy has nothing to do with whether this particular information, the sources of information for her news reports, goes to that issue or is material to that issue or significant or substantial, as that term is defined. And the court in Delaney made clear it has to be something more than speculation, more than a chain of links in a chain of hypothesis or speculation in order to satisfy the materiality and reasonable possibility standards. And that showing hasn't been made. And the court, I think, correctly indicates that if what they want to present to the jury is their argument about this being a Lincoln conspiracy or that there was inaccurate news reports, Mr. Ullman last week said repeatedly to the court, we don't need the sources of information for that. And somehow they've gotten the light or changed their position or something in the space of the last couple of days to now say this information is somehow critical, when he repeatedly represented to the court that they didn't think it was critical and in fact was irrelevant to the argument they wanted to make. But I'd end with simply saying that there is no case that I'm aware of, certainly none cited by defendant, where anything closely approximating these circumstances has resulted in a reporter being forced to divulge confidential sources. No case that I'm aware of where a reporter has been forced to reveal sources based on a news report that the parties say was inaccurate. Certainly not in the context of a criminal case where you have a defendant presenting an argument. This does not go directly to the question of guilt or innocence, or is not directly evidence of any kind of conspiracy, but is simply a series of innuendos or speculation or hypothesis. And for all those reasons, I think that the privilege has not been overcome in this case, and it would be improper for the court to force Ms. Savage to testify and ask her to reveal her confidential sources.
All right, Mr. Ullman, do you have any brief response?
Very briefly. I just want to make 3 quick points. Number one, Mr. Goldberg suggests that somehow we must articulate a theory of when the blood was planted on the sock in order to establish the materiality or relevance of showing the source of this leak. The problem, of course, is the sock was in the exclusive control and custody of the Los Angeles Police Department from June 14th until September 26th, when it was sent out for DNA testing. So we don't know at what point the evidence may have been planted. And the problem, the real issue in this entire question is whether we should have confidence in the integrity of the Los Angeles Police Department in maintaining the custody and control of that evidence. And what we're dealing with here goes directly to the heart of that question. How much confidence should we have in the integrity of those who were entrusted with the care and the control of this evidence? There are a number of inferences that arise. A possible inference of planting of evidence, a possible inference of examiner bias, a possible inference of a conspiracy to prejudice the defendant's right to a fair trial. But until we know who the source of this information was within the Los Angeles Police Department, we can't pursue where that takes us. Once we identify that source, then we know where we can go to clarify, to provide the information that both this court and the jury are entitled to in terms of resolving this very difficult issue. Secondly, Mr. Goldberg makes the point that there was an internal investigation that apparently came up dry, but the only way we can see that is to file a Pitchess motion. We would respond, first of all, if an investigation came up dry within the LAPD, that goes directly to Your Honor's resolution of the question of whether there's an alternative source other than ordering the reporter to reveal the source to find out who that source was. And the fact that the LAPD has internally investigated and been unable to identify the source would, I think, be very useful to the court in addressing that issue. And we believe the court has power to simply order the production of that report for purposes of this hearing in the exercise of its inherent power.
I don't think I can do that given the very strict language of the evidence code after Pitchess that indicates this is the exclusive manner in which these types of records are to be sought.
But a Pitchess motion requires us to make a specific showing that information about a specific officer is relevant to our case. Here we have an investigation that did not apparently implicate any officer. And what its relevance is simply the fact that they made that effort and they were unable to determine what the source was. So we're not really using it for a Pitchess purpose of attacking the credibility of a police officer, but simply showing that the investigation had a negative result. And that's what's relevant to this hearing. Finally, I want to make clear, Your Honor, that what we would propose to do is to call Ms. Savage in the event that she invokes the limited immunity and establishes that the immunity applies before Your Honor applies the balancing test to determine whether to order her to testify, we would like an opportunity to call Michelle Kessler, the director of the laboratory, to further our showing with respect to the relevance and materiality of identifying this source. Yes, that would be outside the presence of the jury as well.
All right, I take it that then you're declining Ms. Sager's offer to submit a declaration by Ms. Savage regarding the foundational issues?
Yes, Your Honor, we would like Ms. Savage to testify.
All right. Ms. Sager, do you want to address that one specific issue?
Yes, Your Honor. In the context of a motion to quash, I'm at least aware of no authority that suggests that a reporter needs to personally take the stand as opposed to submitting by declaration form information which is merely foundational. And in this case, and as in other cases that I'm aware of, the court has accepted a declaration from the individual simply establishing foundational facts. And unless the defense counsel has information which would tend to cast any kind of doubt on any of those foundational facts, and given that the subpoena in question was accepted by KNBC's counsel at the defense counsel's request, I don't think that there is any question about her employment, about the context in which this information was gathered, and certainly I'm aware of no information which would suggest anything to cast into doubt her representation that the information came from sources who had been promised confidentiality. So absent all of those factors, and in light of what other courts in California have adopted as the correct procedure to determine these matters on a motion to quash, it's simply the same as any other discovery motion where the court can take evidence and make a ruling based on evidence before the court. Does not need to be in testimonial form, certainly can be in declaratory form. And the only reason to not do it that way would be if there is something that would tend to cast doubt on information in that declaration. And absent an offer of proof by defense counsel suggesting that information exists, then I think a declaration would be appropriate, and to force Ms. Savage to take the stand would not be an appropriate exercise of the court's discretion.
All right. Thank you, counsel. As to the motion to quash the subpoena for Tracy Savage, the court will deny that motion for the following reasons. The offer that has been made, the preliminary offer that has been made by the defense is sufficient for the court to go forward to at least establish foundationally that she is a news reporter and that her sources as to this broadcast, this specific broadcast, were to be held in a confidential manner. I think that has to be established on the record and subject to cross-examination. So to that extent, the motion to quash is denied, and I'll grant the defense the opportunity to call and question Ms. Savage as to those issues. If in fact, after being asked, will she reveal the sources of those, that information, and if she invokes the Shield law and indicates that even if the court finds her in contempt that she will not reveal those sources, then the court will go into the other issues suggested by Delaney. And if that occurs, this is a rather complex issue that I will not probably be able to determine today. All right, Madam Reporter, what's your status? All right. Ms. Sager, do you want to confer with your client before we proceed? All right, we'll take 10. Is there again present? Where'd Ms. Sager go? Oh, there you are. I'm sorry.
Yes, Your Honor.
All right, ready to proceed?
Yes, Your Honor. I'd ask the court's indulgence in permitting me to interpose objections if necessary on Ms. Savage's behalf, even though she's not a party, given the nature of the inquiry and I'm sorry. Given the nature of the inquiry and that she is not a lawyer, to the extent that any questions might stray into forbidden areas or go beyond the court's foundational, permissive foundational inquiries, I'd like the court's permission to interpose objections.
All right, what I'll allow you to do, Ms. Sager, is to stand to the side of the witness stand, and if you wish to confer with your client, I'll allow you to do so.
Thank you, Your Honor.
All right, Ms. Perlman?
Next is called Tracy Savage.
All right, Ms. Savage?
Please stand by the court reporter and raise your right hand. You do solemnly swear that the testimony you may give in the cause of coming before this court shall be the truth, whole truth, and nothing but the true self of God?
I do.
Please have a seat in the witness stand. And please state and spell your full name for the record.
My name is Tracy Savage, and it's spelled Tracie Savage.
Mr. Ullman?
Thank you, Your Honor. Ms. Savage, what is your occupation,
I'm a television news reporter.
and by whom are you employed?
I work for KNBC TV here in Los Angeles.
And were you employed by KNBC in that capacity in September of 1994?
Yes, I was.
On September 21st, 1994, did you broadcast a news report related to the case of People versus O.J. Simpson?
Yes, I did.
And in that news report, did you report information with respect to some socks that had been allegedly recovered from Mr. Simpson's bedroom?
That's correct.
All right, and what did you report about those socks?
I reported that the socks had been discovered at the defendant's home and that there was blood on those socks, and that the socks had been tested, the blood on the socks had been tested, and the results showed the blood belonged to Nicole Brown Simpson.
And did you report any information with respect to the nature of the tests that had been performed?
Yes, I did.
And what was that?
I reported that a DNA test had been conducted.
And that the results of that DNA test had been reported?
That is correct.
Now, I take it that in making that report, you were reporting what you believed were accurate information?
I reported accurately the information that was given to me from multiple sources.
All right. How many sources?
I'm afraid I cannot answer that question. That is protected by the Shield Law.
But you are asserting that what you reported was an accurate presentation of what the sources had told you.
That is correct.
And were these sources knowledgeable about the investigation of the case of People versus O.J. Simpson?
I object. That calls for conclusion.
Sustain. I think what you can do is ask if she in fact reported that these were knowledgeable sources, and then ask her for what her definition is of knowledgeable.
Thank you, Your Honor. Did you report any information about the knowledge of the sources whom you were quoting in this report?
Yes, I did report that they were knowledgeable sources.
And what did you mean by knowledgeable?
They were sources, and this has been stated already on the record, close to the investigation.
So these sources then were the source of your information that socks had been recovered from Mr. Simpson's bedroom?
Calls for conclusion, opinion.
Sustain. Phrase the question.
When you reported that socks had been recovered from Mr. Simpson's bedroom, you were relying then on these sources who were close to the investigation?
I reported accurately the information that was given to me from multiple sources, reliable sources.
And it was these sources who informed you that socks had been recovered from the bedroom?
That was part of the information that the sources had given to me.
And it was these sources who told you that the socks had blood on them?
That is correct.
And it was these sources who told you that the blood on the socks had been tested?
That is correct.
And it was these sources who told you that the tests had revealed a match to the blood of Nicole Brown Simpson.
That is correct.
And it was these sources who told you that the tests that were conducted were DNA tests.
That is correct.
Now, did you make any promise to these sources that their identity would be kept confidential?
I gave my word as a journalist that I would not reveal their identities.
And this is true with respect to each of the sources that you spoke to?
I gave my word to my sources that I would never reveal their identities.
And you gave that word explicitly? You told them, I will not reveal that you were the source of this information?
Yes, that's true.
Now, were these sources persons who had given you information in the past?
That is true.
And the information they had given you in the past was also related to the case of People versus O.J. Simpson?
Your Honor, if I can interpose an objection here, I know this is somewhat unusual, but this, I think, goes well beyond what the court indicated Ms. Savage would be asked to testify about, which was merely the foundation that she is a reporter, that the information came to her in the course of her news-gathering activities, and that she made promises of confidentiality. With all due respect, Mr. Ullman is now conducting the very inquiry of Ms. Savage, which the court has not yet determined he's entitled to conduct.
Well, Your Honor, we would maintain that this is information that has already been disseminated. In the letter to the court from KNBC, it was represented that the reports were based on the sources with different...
Counsel, I agree with you that I'm already aware that that is the representation that has been made. The issue is to establish the foundation for invoking the shield law, and then I have to make a determination going beyond that once we get to that point. Question's premature.
Now, could you tell us what you mean, Ms. Savage, when you indicate that your sources were close to the investigation?
Same objection, Your Honor. We're beyond now the scope, and I think the foundation has already been laid. There's no need to go beyond what Ms. Savage has already testified to.
Oh, well, how do you define generally knowledgeable and close to the investigation?
Your Honor, I'm afraid by identifying how I determine what knowledgeable is, I may in effect reveal the identities of my sources. Knowledgeable, I think, in all due respect, I think the word speaks for itself.
Mr. Ullman?
Well, Ms. Savage, did you assume that the information given by your sources was accurate because they were close to the investigation?
Well, that's not relevant.
Yeah, we're beyond the scope of the inquiry at this point.
Did your sources include any officers or agents of the Los Angeles Police Department?
I respectfully decline to answer that question. I must assert the shield law.
Again, Your Honor, he's now asking the questions beyond foundational questions.
No, the foundational question, one of the foundational questions were, if you were asked what the sources were, would you invoke the shield? That's where we are. That has been now accomplished. Mr. Ullman?
All right. And at this time, then, you decline to indicate any of the sources on whom you relied for the report of September 21st?
That is true at this time.
Nothing further.
All right, thank you, Mr. Ullman. Mr. Goldberg, do you have any questions? Certainly. All right, Ms. Savage, thank you very much. All right, the court will make a finding that a preliminary foundation has been established. The court will take under submission the Delaney issues.
Your Honor, we would like to call Michelle Kessler with respect to those issues.
Is she available?
She was on
I
notice.
believe she's on phone.
Well, the last we heard, Michelle Kessler had gone this morning to a doctor's appointment for a neck injury that she received
All right,
earlier.
let's do this. As far as Michelle Kessler is concerned, as I indicated to counsel in chambers this morning, one of our other jurors has a medical appointment tomorrow at 4, that we have to conclude at 4 o'clock. Tomorrow. So why don't we schedule that, and since tomorrow is a 6 o'clock day, let's schedule Michelle Kessler for 4 o'clock tomorrow afternoon.
I'd also say about Michelle Kessler, Your Honor, perhaps to short-circuit this, the defense might make a specific offer of proof as to what she can supposedly testify to on this issue, because my understanding, and counsel also had the opportunity to interview her at length, is that she doesn't have any personal knowledge as to the circumstances surrounding this fax and when specifically the leak occurred, and that she only knows these things based upon what she has heard from
But
others.
she may also have knowledge about any internal investigation that may have been conducted. She may have participated in that investigation. She may have been interviewed. There are a lot of things she can tell us about.
And of course, the position of the Los Angeles Police Department, as we have been advised previously, is that all of that is official information under 1040, and that the defense must use the provisions of 1040 in order to try to get that information.
Well, I'm sure we'll see the city attorney tomorrow afternoon.
Your Honor, just...
All right, counsel, what we'll do then now, we'll shift back to Mr. McDonald. We'll bring the jurors down. As I indicated to Mr. Cochran and to Mr. Darden, the court would like to personally inquire of the juror who fell ill last week, just to assure myself that the juror can continue. All right, Mr. Goodell.
Two scheduling matters.
Your Honor, we do have one other witness who will be brief on this issue,
Who is that?
Joseph Bosco.
As to the shield issue?
Yes.
All right, what's your offer as to Mr. Bosco? All right, good morning, Mr. Shapiro.
Good morning, Your Honor. Thank you. Your Honor, Mr. Bosco will offer testimony that he also was a recipient of similar information, that he is a professional journalist, that he has been assigned a permanent seat by Your Honor in the courtroom to cover this case.
No, that's a misnomer. It's a regular seat. There's nothing permanent about it.
Permanent to this date.
Yes,
He has regularly attended all the courtroom sessions.
he has.
And he has published an article that reported the same information that reporter Savage has just testified to, and that he will confirm that he is a recipient of information from a source that told him that DNA test results were in on the socks that were
When?
recovered in the bedroom
When?
in about the same date, September 21st, and that information came from a member of the Los Angeles Police Department who is known to him as a badged member of the police department and a person who is active in this investigation.
All right, do you have, this is published information?
Yes,
And what's the publication?
Penthouse Magazine,
All right, what issue?
the July issue.
All right, so you want to call Mr. Bosco regarding that?
Yes.
All right, Mr. Bosco is present in the courtroom. Good morning,
Yes, he
sir.
is. He is under subpoena.
Good morning, sir.
All right, do you have counsel, Mr. Bosco?
Well, Your Honor, I've been through this down in New Orleans for about a year and a half, and I have counsel down there. I've been through this process. I mean, I could call my attorney in New Orleans who's handled this thing or another case for me for a year and a half. I think, he may holler at me, but I think I know the issue well enough to take the stand, because I've been through it before. Whatever, I might be nice that I call him, but maybe my mother will do so watching the television. Or my wife, I don't know. But whatever your wish is, sir.
No, the wishes are on your behalf, sir. If you wish to have counsel to confer with before you're called as a witness, given the nature of the issue, I'll give you leave to do so if you feel no need to confer with counsel. we can proceed. It's up to you, sir.
Could I just have a few minutes to call in?
Absolutely.
I mean,
Why don't you do this?
I'm not denying, I mean, I will,
Mr. Bosco, let's do this.
yes, sir?
Why don't you report back to the court when we come back after lunch at 1 o'clock? I'll give you plenty of time to locate your counsel in New Orleans.
Yes, sir.
All right? Confer with him by phone. If you feel it's necessary to have local counsel, we'll accommodate you. All right, so why don't you take care of that when we recess? All right?
Yes, sir.
Thank you.
All right.
There's also the issue of the Gretchen Stockdale tape. When is the court going to hear that?
Well, I think I have my plate full with this particular issue. Don't you agree?
This should be a no-brainer, Your Honor, frankly, on the,
Well,
excuse the colloquialism.
well, you'll make a much better judge than I ever will if you think that's a no-brainer. All right, we need to take a recess to bring the jury down. All right, we'll take 10 to bring the jury down. Parties are again present. Record should reflect that the court held a chambers conference with the juror who fell ill yesterday. Oh, I'm sorry. I have to say it again.
Real time is not working.
I don't know. I hear they may go on strike. All right, back on the record in the Simpson matter. All parties are again present. The record should reflect that over the recess, the court had the opportunity to meet with the juror who fell ill last week in the presence of counsel for both sides, and both the court and counsel, I believe, have assured ourselves that that juror is able and willing to proceed with jury service, continued jury service on this matter, and with just minor adjustments for ongoing medical treatment for that condition. So the court is satisfied with that inquiry. All right, Mr. Neufeld, you indicated there was something preliminary you wanted to bring up before we start with Mr. McDonald.
Good morning, Your Honor.
Good morning, sir.
Actually, even before I bring up the preliminary matter, just a quick scheduling issue.
Yes, sir.
It was suggested that perhaps we'd hear from Michelle Kessler at 4 p.m. tomorrow afternoon.
Correct.
Just so we're absolutely clear on this, it was the defense intention, Your Honor, that after we finish with Professor McDonald, that we would play the tape of Paratus, but that only takes about 10 or 15 minutes, that we'd hope to resolve the Savage-Kessler hearing testimony in advance of hearing Kessler's trial testimony. But Kessler was going to be the next trial witness after Tracy Savage, in front of the jury, that is. This just throws, a little bit of a monkey wrench into the works.
Well, here's the problem. Despite what Ms. Lewis might think, I don't consider this to be a no-brainer issue. It has very sophisticated issues, sub-issues, and it involves reviewing very carefully the record regarding materiality. This is not a decision that I'm going to make sitting here without any thought, contemplation, and going over the issues.
I'm sorry, if I can indicate this. Ms. Lewis was referring to the Gretchen Stockdale issue, not the Kessler issue.
Well, that's not the way I understood her comment.
All I ask...
And she's entitled to her opinion. If she thinks it's a no-brainer, like I said, she's much brighter than I am. Go ahead.
All I ask is that since we were proceeding internally
No, I
under that
understand.
premise...
But the problem is, counsel, what I'm saying is that I don't want to be pushed into making a decision on this faster than I have to.
No, I think what you're saying makes perfect sense. All I'm saying is we'd like to get back to sometime this afternoon. If we have some small gap, maybe we can move Kessler up to the early part of tomorrow afternoon if need be, or something. I'm just saying that we may have a little difficulty in filling that void with other witnesses who are prepared at this moment. That's all.
All right.
That's all I'm saying. I can report back to the court
I
later this
understand that.
afternoon with that information.
I understand that, and if we have to have a gap here and there, that's something that we'll have to deal with. I understand Ms. Kessler, my clerk gave me a note that Ms. Kessler apparently has a personal funeral obligation tomorrow afternoon, so that may be a problem as well. I don't know.
Right. So maybe we could take her earlier then, so we wouldn't interfere with that obligation, if the court so desires.
If time permits, we will.
Okay.
So why don't we finish Mr. McDonald first?
All right. With respect to Professor McDonald, Your Honor, there is one brief point that I think has to be resolved before we resume the direct examination. You may recall that that the prosecution made a motion to exclude Professor McDonald's glove drying experiment. And at that point in time, Your Honor, when we had discussion and argument about that motion, and you ruled against the prosecution, you made some remark about, well, perhaps the Buffalo pictures might be displayed, then you said, forget it. I was concerned about that remark, because obviously the court was not expressing an opinion one way or the other. It's just something that came to your mind. We then became concerned that perhaps the prosecution might think, and I believe mistakenly, Your Honor, because I don't believe there's any legal basis for it, to use those photographs that they have chosen either because they chose not to for strategic reasons or chose not to because they believed they would be inadmissible. In either event, they didn't try and introduce those photographs as part of the direct case. That they might mistakenly believe that they could now introduce those photographs to cross-examine Herbert McDonald. I'm making this application now, Your Honor, because I want to be very, very clear to the court that it is our position that if the court will allow the prosecution, in a sense, to intimidate the defense into not going forward with this compelling evidence because of the prejudicial nature of those photographs or those videotapes, we will refrain from introducing the glove drying experiment. And that's why it is essential that we know before we complete the direct examination what the court's ruling on that will be. Now, the defense's right to put on a defense, if you will.
Well, let me see if I understand. You want to put on this glove drying experiment, which I have indicated that I'm going to allow you to do.
That's correct.
All right. But you are afraid that if during the course of Mr. McDonald's cross-examination the prosecution has photographs or videotapes of Mr. Simpson wearing gloves in, say, for example, winter conditions in Buffalo, you're worried that that will have some devastating effect upon your ability to present a defense?
Your Honor, it is.
Because when I made that offhand comment, which I should learn not to do, obviously, the only reason I mention that is that in establishing the materiality of your glove drying experiment, obviously those experiments were conducted upon the new gloves, the Aris lights, if I'm not mistaken, that the Aris Corporation was kind enough to provide to the court. The only issue being that obviously for cross-examination purposes, I could do this cross-examination in 10 questions, one of which would be, did you use new gloves? Did you take into consideration shrinkage that occurs over a period of time? Did you take into consideration the tanning methods, the silicone impregnation of leather to prevent moisture problems, that sort of thing, and then show a picture of the defendant wearing gloves in winters? I mean, that's pretty simple, wouldn't you say?
Well, yes and no, and I'll tell you why it's not, Your Honor.
All right,
You
tell me why it's not.
may recall when I was examining Robin Cotton, and I started asking her some questions about swatches heating up in the back of a truck in Brentwood, and you wisely cut me off and said, what is a New York lawyer doing asking questions to a Maryland scientist about weather conditions in June in Brentwood? Well, that was a good point on your part. But equally true, Your Honor, I don't know how much people in Los Angeles know, because of the luxury of living in this climate, about wearing gloves in the cold Northeast. And I can tell you, Your Honor, and anybody else who wears gloves in the Northeast will tell you, that we wear gloves out in the snow, we wear gloves out in the rain, and they don't shrink. We do that all the time. We bring the gloves back in our houses, and they don't shrink. And we wear the same gloves for years and years and years when we're adults, and the only reason we replace them is because we lose them or misplace them, not because they shrink. The only testimony you heard, in fact, on the shrinkage issue came from Richard Rubin, who said specifically that, in his opinion, if you did dump them in a lot of liquid, okay, and then, depending upon how quickly they dried and those circumstances, that could cause some shrinkage. But remember, we're not talking about some shrinkage here. We're talking about, by the prosecution witness's own testimony, 10 to 15% shrinkage. And there's been no testimony at all from any prosecution witness during their case that weather can account for a 10 to 15% shrinkage. None at all. Freezing and thawing doesn't do it. When I go out in the winter, when I lived in Wisconsin and it was 30 below zero,
All right.
those gloves are freezing and you come inside, they thaw out, they do not shrink. Gloves don't do that.
Mr. Neufeld, let me ask you this, though. Isn't this sort of premature, given the fact that they're not obligated in cross-examination and impeachment of your witness to divulge what they have? And I've indicated to them that before they present anything similar to what we just talked about, that we'll have a motion at sidebar to determine whether or not that's going to be used.
No, I think, Your Honor, it's not a question of them showing particular photographs right now. I'm not asking for that. What I'm saying is that this entire line of inquiry would be impermissible, showing any photographs or any of videotapes, because there was absolutely no foundation that was laid during their case at all that the weather conditions can account for a 10 to 15% shrinkage. In fact, the only theory proffered by the prosecution during their case was that gloves smeared with a large quantity of blood could account for a 10 to 15% shrinkage. That's the only theory they advanced, and it's because of Mr. Simpson's Sixth Amendment right to confront that theory, to put on a defense, that we engaged Herbert McDonald to conduct that experiment after the prosecution rested, just for that narrow purpose. They have a right to do their own shrinkage experiment. I don't have a problem with that. We've opened the door to that. But there is no question in my mind, Your Honor, that photographs showing Mr. Simpson wearing gloves at a Buffalo Bills game, at a Cincinnati Bengals game, in the winter, does nothing at all to cross-examine or impeach this witness's testimony. If they wanted to do experiments on blood, that would. But merely showing that he wears gloves in the outdoors in the winter doesn't do it. There is no evidence to suggest that wearing gloves in the winter will cause a 10 to 15% shrinkage. I know of no such person who would ever testify to something like that. And so what the prosecution is really trying to do here is simply prejudice the jury, not with probative evidence to explain shrinkage, but rather with shots of Mr. Simpson wearing brown leather gloves.
Okay, hold on. Is there a response from the people?
I don't know what kind of gloves Mr. Neufeld wears. They must be very magical gloves. I think everybody in the country has written to us about the shrinkage that occurs when you wear gloves in the winter. I lived in New York. I know what happens to gloves when they get wet and then they dry. Mine shrunk. I don't know. I'd like to buy the kind that Mr. Neufeld gets. They're great. But as far as I know, my experience, and I think that of millions of Americans, is that gloves, when exposed to weather, shrink.
That's not the issue. The issue is, do you intend on presenting evidence of Mr. Simpson wearing gloves in wintertime?
Why do we have, does the court requiring us to tell them that now?
No, I'm not. But you could save me a lot of trouble if you said, no, we're not going to do it.
I can't promise you that, Your Honor.
All right.
I really can't. No, I mean, I think it's, you know, all kidding aside, it's obviously germane. They undertook to do these experiments on brand new gloves under totally different conditions. That's fair grist for the mill on cross-examination. We didn't tell them to conduct the experiment in this manner. They've set themselves up for a fall by doing it in the way that they did. You pay your money, you take your chances. And that's all we're saying.
So I take it your position is that since it is cross-examination, at this point, it's not something that you need to divulge in discovery.
That's correct.
All right, but we've seen when this glove issue came up in the commercial news media, we saw several sportscast replays of Mr. Simpson in wintertime
That's true.
wearing gloves.
That's true.
All right. Can you establish a foundation that those gloves are the same gloves?
Yes, I can.
Interesting. All right. Let me see counsel at sidebar without the court reporter. All right, thank you, counsel. Mr. Neufeld?
Yeah, Your Honor, the only additional point I wish to make is I'm making a specific proffer so the court will know at least the parameters of Professor McDonald's testimony on this issue. I laid out most of what he would say in my moving papers with the accompanying photographs which the court saw. I just want to be very, very clear to the court that Professor McDonald took the other new pair of gloves that were provided by the Isotoma Corporation, basically identical to the new gloves that Mr. Darden used in the second demonstration in the courtroom, and that he took them and smeared as a large amount of blood on both gloves, as much as they would absorb, in fact, rubbed it in, that he then tried to replicate the climatic conditions at Bundy and Rockingham for that evening by relying on U.S. Weather Service reports regarding temperature, dew points, humidity, the like, that he used a special humidity chamber, in fact, designed by the Corning Glass Company to do that, and that as a result of that experiment, he simply learned two things. One, that the approximate drying time is about 4 hours, and that two, when he compared the gloves after they were dried to their size before they were moistened with the blood, that there was no observable shrinkage. And that would be the extent of his testimony. And so it's our position that, since that's all he will testify to, that they are precluded from cross-examining him with any photographs or videotapes showing Mr. Simpson wearing brown leather gloves.
All right. Counsel, I think that if you bring in evidence regarding this experiment as to how these gloves did not shrink under your experiment, the prosecution is entitled to cross-examine on factors that were not taken into consideration during the course of the defendant's experiment, such as the age of the gloves, other weather exposure, the particular materials that were involved in with this particular glove, the nature of how the leather was manufactured, what kind of water repellency treatments were placed on it, whether or not any of these things were taken into consideration. I think that's fair game for cross-examination.
The only little point I would add, Your Honor, is that I don't doubt that they have the right to cross-examine him on all those points and ask him whether he took those into account. By the way, the only little remark I would make is you may recall that Richard Rubin testified that these gloves were made with naked leather. That was his word. And so there are no preservatives. There are no... There's no chemicals to resist moisture or anything else. So the fact that it's just naked leather is not going to change over a period of time.
Well, there's some chemical constituency in the tanning process, but go ahead.
But we're not disputing, Your Honor, that the gloves in question are older gloves and are not new gloves. The jury's seen the gloves and they know they're older gloves. That entire cross-examination that you just described would certainly be permissible, but the ends of that
and would only take about 10 minutes.
But the ends of that cross-examination is qualitatively and quantitatively different from enabling the prosecution to show photographs of Mr. Simpson wearing brown leather gloves in the winter. We're not disputing that, that gloves are worn in the winter, that Mr. Simpson has worn gloves in the winter. 3/5 probably of the population have worn gloves in the winter. That's not a very probative point at this time. However, showing him wearing brown leather gloves is very prejudicial, and I don't see, Your Honor, quite frankly, the relevance of showing him wearing gloves on a cold winter day in Buffalo has to do with the rest of the cross-examination, which is perfectly permissible, about did you take into consideration that the gloves are old, did you take into consideration that it may be out in the weather?
Well, when I discussed this issue with counsel previously, I indicated that before any videos or photos were presented during the cross-examination, that the court would have to see them first and make a ruling at that time. So the objection at this point is premature.
Well,
but given the parameters of what I've indicated, I think you understand the court's ruling.
One second, Your Honor. I would just like the record to reflect that without the ruling that I believe we're entitled to at this time, then the defense will not introduce that glove drying experiment through this witness.
All right, well, that's a tactical decision that you're making based upon not knowing the results of a ruling that has yet to be presented, an issue that has yet to be presented to the court, and that the prosecution not being obligated to present that to you, since it's impeachment, this is a tactical decision that you're making on behalf of your client. So I just want the record to be clear.
I understand that, Your Honor. I just believe that I think under the Sixth Amendment, we have a right to a ruling beforehand.
All right. Okay. Let's have the jury, please.
I wanted to mention that the comment I made earlier was with regard to the Gretchen Stocktail motion.
Let's put that to rest.
Well,
That's,
I'm sorry
I'm
for
not
the
even
ambiguity.
thinking about that right now, counsel. Let's have the jury, please. Gentlemen, please be seated. The record to reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. First, I'm happy to see all of you back here today, and you all seem to be fit and ready to proceed. Secondly, my apologies to you for keeping you waiting so long, but we had a number of interesting legal issues that I had to deal with before we were able to continue with Mr. McDonald's testimony. All right, Professor, would you resume the witness stand, please? All right, the record should reflect that Professor Herman McDonald is again on the witness stand undergoing direct examination by Mr. Neufeld. Good morning, Professor.
Good morning.
Sir, you were reminded that you were still under oath, and Mr. Neufeld, you may continue.
Thank you. Good morning, ladies and gentlemen. Now, Professor McDonald, in this case, you mentioned, I believe, last week that you were retained by the defense. Did you not?
Yes, I did.
Okay, and you are, of course, testifying at this trial. Is that right?
Yes, obviously.
All right. Now, could you please give us an estimate, over the last 2 years, approximately how many cases have you been retained either by the prosecution or the defense?
Probably somewhere between 50 and 75, more likely the 75.
And do you have an estimate about the approximate percentage, which would be cases where you were retained by the prosecution, and an estimate as to the percentage of cases where you were retained by the defense?
I would say about 50% for the defense and perhaps 40% by the prosecution, and 10% might be private or other investigations that would be civil rather than criminal.
Now, of all those cases that you just described, the 75 to 100 cases in which you were retained to examine and analyze evidence, and approximately how many of those cases did you actually come to court and testify at a trial?
About 10%. That might be high. I do not testify that often in court.
Sir, is one of the reasons that you testify so rarely compared to the number of times that you are retained because your findings did not help the side that retained you?
Sustain or rephrase the question.
Okay. Do you know the reasons why you testify so infrequently comparatively to the number of times where you're actually retained by one side or the other to examine and analyze evidence?
Yes.
Overruled. The answer is yes.
Yes.
And could you please tell us what the reasons are?
Overruled.
The reason is that when I'm asked to investigate a case and examine physical evidence or go to a crime scene, there are times when there is absolutely no evidence that can be useful in determining what occurred. The evidence may be too old, it may just not exist. And so if there is nothing that I can conclude that is of any value to either side, naturally I cannot write a report, I cannot give any information. On occasion, when I investigate a case for the defense and the findings would not be helpful, they do not call me to testify.
Now, what I'd like to do is resume the discussion we were having on Thursday concerning the ankle stains on sock 13A. I'd like to show you, Professor McDonald, Defendant's Exhibit 1278, 1277, and 1276, which you had looked at last week. If you recall that when we left off last week, you were explaining your observations regarding the ankle stain on sock 13A.
Yes, I do.
Okay. Now, based on your observations, Professor, and expertise in the area of bloodstain interpretation, what conclusions did you reach concerning the stains on the ankle of sock 13A?
Well, I concluded from Exhibit 1276 that the overall stained area, which surrounds the cutout portion, was the result of a transfer of blood to that area and not projected. It's a very large stain, and blood does not spatter in that large an area. It might splash, but it doesn't spatter. That would take a very large volume of blood. But this is transferred to the surface of the fiber on the outside. And looking at 1277, the photomicrograph taken by Dr. Lee and myself shows the high spots of the weave, the upper portion which are brushed with, which I believe has been identified as blood.
Professor McDonald, by the way, while you're giving this explanation, if you would be so kind, if you can hold up the photographs to the jury so they can at least see what it is that you're describing. Actually, why don't I use the...
Do you want to put it on the Elmo?
It might be easier on the Elmo.
This is 1276, if I'm not mistaken.
That's correct. Can you see that well, Professor?
Yes, I can.
Okay. So what were you saying you learned from your observations? What conclusions did you make beginning with this photograph, and then we'll move on from there?
But I concluded that the stain which surrounds the cutout portion, which is much lighter in appearance, in almost a yellowish red coloration on this screen, was the result of a transfer of a liquid to the surface more as a direct compression rather than a side or lateral movement, which we call a swipe pattern, because of the peripheral bonding of blood to the top of the fibers, which is shown in, I think it's 1277, more accurately.
Okay. And now referring you to Appendix 1277, based on your observations and expertise in the field, what conclusions did you reach about the that stain on the outside perimeter of the area that had been cut out?
Well, as stated, the area to the left circled in blue is a reflection of a red glistening substance which has previously been identified as blood. And on the right side, in the lower right, there's a dark circle showing the area which is not glistening insofar as having a red coloration. That is just the black fiber which under high-intensity illumination appears to be white in this picture. But that's the void area, and the stains are on the surface of the fibers, and they're not distorted. They're very sharp, very clear. That is one of the things that I considered in the swipe-type pattern or transfer pattern that occurs.
Now, again, based on your observations of the socks and based on your expertise in this area, sir, what additional conclusions did you make regarding the stains seen in the sock area?
Well, the other red substance that I saw was not on the surface of this fabric. Maybe I could demonstrate better. I'm looking at the outside of what is called the left side of the sock. Whether it's a right sock or a left sock cannot be determined, but it's the left side in the ankle area.
I'm sorry, 1 second, Professor. Your Honor, could you just inquire with the jurors as to whether or not they can all see what Professor McDonald is doing?
I don't believe they can.
All right.
I'm referring to the outside of the left side of a sock. Whether it was the left foot or the right foot, again, is not clear. This area has been cut out. It's stained and cut out. I continued the examination when the socks were lying flat on a table surface in the laboratory and observed additional red balls of blood on the inside of the side opposite this cutout portion. And that's what the greater enlargement that has been introduced, probably 1278, shows one of those bonded, dried, liquid red materials.
And are there any additional conclusions you've made
Well,
regarding
yes.
the relationship of these stains?
That's what I saw. I hadn't got to the conclusion.
I'm sorry.
The conclusion would be, obviously, that if the stain directly opposite the cutout portion on the inside is in any way related to the stain itself, then the staining occurred when this material soaked through and stained the inside of the side opposite. I would conclude that is what happened.
Your Honor, with the court's permission at this time, I would like to pass around 1278, I believe, which I did not pass around to the jurors last week.
Certainly. If you'll hand that to juror number 1, please.
I give it to juror number 1.
Juror number 1. 1278 from Deputy Smith, please. All right, the record should reflect that each of the jurors has now had the opportunity to view Exhibit 1278. Mr. Neufeld.
Professor McDonald, what is it about the way that red ball is configured and bonded to the actual fiber that you find to be significant in that photomicrograph?
As I'm holding this, so the label on the back is up, to describe that little red area simply shows that it is a round, glistening, reddish, ball-shaped configuration which I interpret as being bonded to the fiber to its lower right. And that fiber is woven into the overall thread, so that that spot of red fluid dried, when it was wet initially, dried on a fiber bonded. Therefore, it is part of a liquid transfer and not a addition by flaking or powdering or something that may have broken off when a cutting occurred on the area above it.
And sir, I hate to burden with you one more time, but it has been suggested that when you use your own socks, it may not have been completely clear for everybody. I will take one of Mr. Cochran's socks and have it next in order, Your Honor, which is
1279, I believe. 1279.
And could you, for demonstrative purposes, sir, simply describe to the jury where you saw stains, simply using this sock as an example? Hold it up, please.
Much better socks than mine. This area right here, in the ankle area.
I'm sorry, 1 second also. If, with the court's permission, may the
Why don't we
witness
have
step
him
down?
step down right to the rail here?
Yeah.
And please keep your voice up, Professor.
The general area of the outside on what I am calling the left side of the sock, for my purposes of identification, this would be the right side, again, regardless of which foot it happens to be on. On the left side, the overall inch by inch and a half stain is seen on the surface. And when it's cut out, there is on the inside of the side opposite, it'd be the inside here, if we turned it inside out, this is where there is transferred liquid that's dried. And I interpret that as being part of the staining action here at the time this was wet and went through, without a foot inside, obviously.
There'll be an objection to that, Your Honor.
Well, I'm sorry, 1279? What about 1279?
1279, I would ask permission actually at some point to substitute it if I could, since
Yes,
it's a generic item.
yes.
Thank you.
The objection is that the latter opinion stated by Mr. McDonald calls for speculation, and that there's no foundation.
Overruled.
Professor, let me ask you a hypothetical. Assume that a doctor examined Mr. Simpson head to foot on June 15th, and there were no cuts, scratches, or scrapes observed on Mr. Simpson's ankles. Would what you observed on the sock, when you examined it, both with the naked eye and with the microscope, be consistent with a blood stain passing through one side of the sock to the other when the sock is not on the foot and is instead lying flat on a surface?
Yes, it would be consistent with that.
Overruled.
And why is that, sir?
Well, as I stated when I had the sock on this board, if there's something like a foot inside the sock, unless there's a tremendous hole right through the ankle, there's no way that anything can go from one side of the sock to the other simply by transferring from the inside, the left or outside portion, through to the inside of the opposite side or the right side.
Same objection, Your Honor, it's an incomplete one,
Overruled.
Now, sir, over the last 40 years that you have been working with blood, have you investigated the drying time of blood on different surfaces?
Yes.
How is it that you are familiar with the various drying times of blood stains under different conditions?
Objection, Your Honor, ask for approach.
With the court reporter, please. Thank you, counsel. Proceed.
Thank you. Professor McDonald, could you please tell the ladies and gentlemen of the jury, how is it that you are familiar with the drying times of bloodstains under various conditions?
The institutes that I began directing in 1973, of which there have now been 43, have an experiment where we do drying times of blood in fabric, on wood, glass, various surfaces. This is done in small volumes and in large volumes, and also with many fabrics. This is a routine experiment that has been done for many years. The amount of time required is such that for the larger pools of blood, we can't do that in a single day, so that was deleted from the fourth publication. We still do, in experiments 12 and 13, some of the blood that is spread out to see how rapidly it will dry, put on clothing, particularly fabrics that are difficult, like Arnell and nylon combinations, that appear to be stained on one side. In fact, they were stained on the other. So we're aware that there are very dangerous areas in looking at a sample of material and trying to identify which side was stained without doing the actual experiment. So we do this routinely. I've done it on, I don't know how many cases. I would say perhaps 100, 200, 300 cases where fabrics are involved. We will usually test the actual fabric to determine transfer characteristics and drying time. That's how I'm familiar with it.
And sir, based on those demonstrations and experiments that were conducted routinely in the institutes by your students that you just described, does the volume of blood on an object affect the drying time?
Oh, certainly.
And how is that it affects the drying time? Simply.
Well, the more blood there is, the longer it's going to take to dry, given the same surface area. A pool of blood that is contained, for example, in a bowl is going to take much longer than the same area, but a very thin film.
And, sir, did you estimate the approximate volume of blood that originally existed on that stain on the ankle in 13A, sock 13A?
That's the same as 42A.
Yes.
Yes, I estimated the volume to be approximately 1 drop. It is not soaked through on the periphery. Those are the pictures we've seen, 1276, I believe. 1277, excuse me. That shows the blood on the surface, at least on the periphery. The center has been cut out, and it would have been slightly heavier. So that stain could be caused on that material, I would estimate, with just 1 drop, 50 microliters, perhaps slightly more or slightly less, but I would estimate 1 drop would be adequate.
Okay.
Oh, well,
Now, you said that the drying time is affected by the volume of blood. Is it also affected by the type of surface that the blood is drying on?
Yes, definitely.
For instance, does it make a difference whether it's drying on fabric as opposed to a glass table?
Yes, the fabric would act as a wick, so to speak, up to a certain point, and it would allow the blood to dry more rapidly. But if it's a thick fabric, it would act as a reservoir, and it would contain the blood and reduce the surface area, so it would dry slower. Blood spread out on a surface, just a tabletop or anything, if it's a thin film, will dry very rapidly. If it's a small spatter, a small 2 millimeter to 1 millimeter diameter spot, it will dry very quickly. Within a matter of a minute, you can just wipe across it, and it will be dry. So it depends a great deal on the surface.
Sir, even within that subcategory of surfaces, which we'll call textiles or fabrics, will there be variation in the drying time between different types of fabrics?
Yes, we conducted experiments of that type to present a paper to the American Academy of Forensic Sciences some years ago dealing with the effect of enzymes in detergents. Several years ago, there was Tide XK and all of these little bugs chewing up the stains.
What I'm asking, sir, is not so much the chemicals that an item may have been treated with, but is there a difference in drying time, for instance, between synthetics and natural fibers?
Yes, we use those in that paper.
And all things being equal, given the other factors, what is the difference in drying time between, let's say, a synthetic, which the sock is of in this case, and cotton?
If you have a synthetic fiber, it is non-porous. It does not itself soak in a fluid. Notwithstanding, the fluid will soak in by capillary action or just a wetting in between the individual fibers. But a natural fiber, such as cotton, ramie, hemp, jute, some of those things, are porous. Wool, for example, is porous. Animal fibers are porous, but not to the extent of some of the natural fibers. So therein you have soaking not into the weave, but also into the individual fibers. And again, that retards the evaporation or the drying above and beyond synthetics, where the blood is exposed, although in between some of the fibers which do not absorb blood.
If I was to try and distill that, at least for myself, Professor, would that mean that all other things being equal, that blood will dry more rapidly on a synthetic fiber than on a cotton fiber?
Of the same type of weave and thickness, yes.
And sir, is there a difference in drying time for blood if it is dabbed or smeared on a surface versus blood that has simply fallen onto a surface or dripped onto a surface?
Well, if the dripping blood actually penetrates the fiber and goes down into the fiber, it wets it, in other words, that will dry much more slowly than if you just have it on the surface where there's air can actually get underneath it through the fiber.
And I believe you testified, so that in your opinion in this case, the blood stain found on ankle 13 is a result of a dabbing of the surface as opposed to blood simply dripping or spattering onto the surface.
Sustained. Phrase the question.
Okay. Is it your testimony, sir, in this case, based on your observations of the ankle stain, that the blood did not spatter onto the ankle area of sock 13A?
Yes, it is.
Is it your testimony, sir, that the blood got there by being the result of some kind of compression, some object brought to bear on the sock, and that object had blood on it?
Yes, it is.
Overruled.
Now, sir, in addition to those factors which you've already described, is there a difference between the time needed to air dry a blood stain versus when the stain is on material that is actually in contact with a living body, such as a sock pressed up against an ankle?
Yes.
And could you explain to the jury what the difference is in drying time?
Sustained.
Could you explain to the jury what effect it has on drying time for the item of clothing which has the blood to be in contact with a living human body as opposed to when it is air dried?
Objection, no foundation.
Sustained.
Sir, have you compared in the past, prior to your involvement in this case, the different times in which an identical blood stain will dry if it is air dried as opposed to being in contact with a human body, with material that is in contact with a human body?
Objection, that's irrelevant, so
Overruled.
they, in contact.
Overruled.
Yes, over the course of many years, I've conducted experiments where fabric was actually placed on a person's arm or leg, and blood was impregnated into that material. The drying time and the soaking through characteristics were the object of doing that experiment. I can cite at least one case where we did that using identical twins, so the blood groups would be identical.
And sir,
Irrelevant, motion to strike.
Overruled.
based on your expertise, does blood dry faster or slower when it's on material that is in contact with a person's skin when the person's living, as opposed to when it is simply air drying and not in contact?
Objection, insufficient foundation.
Sustained. Clothing is not all uniformly worn on a body, counsel.
I mean, we have a sidebar.
It's as directions I give you, counsel.
all things based on your experiments, I'm sorry, based on your studies and experiments, even prior to your involvement in this case, all other variables being equal, is there a difference between the drying time of blood on a fabric that is simply in the air drying as opposed to blood on a fabric which is in contact with a living body?
Objection, no foundation.
Sustained.
Have you done experiments to answer that particular question prior to your involvement in this case?
That's been answered.
Overruled.
Yes, I have.
Could you please describe what experiments you've done of that nature where you would actually compare the drying time where all the other variables are identical except for the one variable being the fabric is against the skin of a living person as opposed to the fabric not being against the skin of a living person?
Objection, irrelevant.
Overruled.
Yes, we've done experiments, as I stated, to determine both the drying time on a person and drying time of that fabric in air. And because living people are warmer than the environment, with the exception of some of the weather lately, you will have blood drying on the garment much more rapidly.
Foundation.
Overruled. I mean, sustained, answer stricken. Juries did completely disregard that last answer. Proceed.
Professor McDonald, well, this way.
Professor, have you done any of these drying experiments on socks prior to this case? Synthetic socks?
Not on the garment in a sock configuration, no.
Thank you.
Have you done it on synthetics that are very sheer and light like the socks?
Yes?
And have those experiments done on sheer synthetics that are light and sheer like the socks been done where one part of the fabric is in contact with the body, picking up the body heat, and the other fabric is simply air drying?
Yes?
And based upon those experiments, sir, what is your expert opinion as to which will dry faster?
Objection, no foundation.
Sustained.
Right. Professor McDonald, I'm not going to introduce. The prosecution has entered into a stipulation with regard to the next exhibit, which shall be
1281.
1281, which is the official records of the U.S. Weather Service, National Weather Service, at Los Angeles Airport for June 12th and June 13th.
Thank you.
Do you have a copy of these, sir?
Yes, I do.
To be corrected, 1280.
1280.
1280.
chance to examine the National Weather Service statistics for Los Angeles Airport for the evening of June 12th and the morning of June 13th, 1994?
Yes, I have.
Okay. And first of all, can you tell us, sir, what was the temperature range between approximately 10 o'clock in the evening on June 12th, 1994, and 9:30 the morning of June 13th, June 13th?
Objection, the report speaks for itself.
Overruled.
The temperature range was between 63 degrees Fahrenheit and 66 degrees Fahrenheit, according to the document I have.
And during that same period of time, sir, when you said the temperature range was between 63 and 66 degrees, does it also state what the dew point was?
Yes, it does.
And during that same period of time, sir, is there any indication from the official National Weather Service printout here that there was any dew on the ground on the night of June 12th into the early morning hours of June 13th?
Well, it indicates that the dew point range was below the temperature range all the time, so there would have been no dew formation.
And how much below?
Objection, that's no foundation.
Sustained, answer stricken.
Could you please say, sir, what was the closest the dew point ever got to the temperature during that 12-hour period?
I'm sorry, counsel.
Objection, Your Honor.
Wait. You're having this witness testify to atmospheric conditions during the course of the...
No, all I'm having this witness do, Your Honor, is testify to...
This is beyond what he's qualified to testify to at this point, so the objection is sustained.
Your Honor, I believe that once the court takes
The
judicial...
objection is sustained, counsel.
May we have a sidebar, Your Honor?
No, you may not. Proceed.
All right. You said that the temperature between those hours of approximately 10 o'clock on the evening of the 12th and 9:30 the next day were between 63 and 66 degrees. Is that correct?
That is correct.
What is body temperature, surface body temperature, sir?
It's slightly less than,
Sustained. Surface body temperature?
Of a human being.
Sustained.
Are you familiar, through your studies, sir, on what the surface body temperature of a person is?
only that it's below the temperature of blood.
Objection, Your Honor, objection, no foundation.
Overruled.
I'm sorry, could you please answer the question?
So it's below the temperature of blood, which is 100 degrees. Body temperature is 98.6. I think the surface temperature is several degrees below that, depending upon the environment. Because if it's a very cold day, your skin will be cooler than on a hot day. I think that's common sense.
To your knowledge, to your knowledge, sir, and based on your experience, will the body temperature of a living person always be greater than 63 degrees Fahrenheit?
And it is unless they're freezing.
Sustained. Excuse me, Professor, if there's an objection being made, don't
I'm
answer the
sorry.
question. Thank you. Proceed.
By the way, while you have those certified records in front of you, sir, are you aware of the fact that when Dr. Lakshmanan of the medical examiner's office testified, he said that on June 13th at about 1:46 p.m., the temperature was 64 degrees. Page 32052 of the transcript. Was Dr. Lakshmanan correct or incorrect when he gave that testimony?
Well, objection, Your Honor, that's irrelevant. It's also
Sustained.
not-
Dr. Lakshmanan was not at the crime scene, counsel.
Dr. Lakshmanan though, testified as to what the actual temperature was.
He wasn't there, counsel.
Your Honor, may we at this point recess for lunch?
Certainly.
And may we also have a sidebar?
Yes.
Thank you.
All right, ladies and gentlemen, we're going to take our recess for the lunch hour. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations.
Keep the noise down.
Don't conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. Stay healthy. See you at 1 o'clock.
I have furnished Mr. Morrell with a copy of the article, and I have no objection certainly to Mr. Bosco and Mr. Morrell taking as much time as they need to prepare this matter.
All right. Mr. Morrell, we have a 4 o'clock end of the court day today, so whatever, you're very familiar with these issues, I'm sure, so, good afternoon, sir. Yes.
Good afternoon, Your Honor.
I feel like I'm being tag-teamed today.
Well, I'm not here representing the ACLU, Your Honor. I'm here representing Mr. Bosco. And I was called on this matter 20 minutes ago, and I apologize for not watching this morning's proceedings. I was engaged across the street in the federal court. So I really am very much at sea in terms of what has already occurred. I don't want to be duplicative. I don't want to waste the court's time. Perhaps if we could arrange to take this matter up tomorrow morning, I would be at least more prepared at that point to address whatever the issues are.
All right, why don't you converse with Mr. Shapiro, who is the person interested in calling your client, talk to Mr. Bosco, and then let me know what your status is.
At the end of the day today, or, okay, but, all right, and I'll contact the clerk about that?
Yes. All right, thank you. All right, Mr. Cochran, good afternoon, sir.
Good afternoon, Your Honor. I would like, if I could, to put something on the record at this point, as I indicated to the court earlier. The court is aware that last week the court was kind enough to issue a subpoena for Miss Laura Hard McKinney in North Carolina. And I had the pleasure of journeying to North Carolina on Friday morning, where I was able to read transcripts and listen to a very small portion of the tape. There are some 11 or 12 hours of tapes, Your Honor, regarding Mark Furman. The judge allowed us to listen to a very small portion of those tapes back in chambers. The thing that I wanted to call to Your Honor's attention and solicit Your Honor's assistance on, the court and Judge Wood in Winston-Salem, North Carolina, failed to give full faith and credit to the subpoena that Your Honor had issued on some basis that he felt this wasn't material. I argued strenuously, Your Honor, that after having heard the portion of the tape that I heard, and I can represent the court, it was Detective Furman's voice, and I can tell the court that these tapes and these transcripts were from a period April of 1985 to July of 1994. We didn't hear all those tapes. We heard just enough to make sure it was his voice. I also called this lady, Miss Laura Hart McKinney, to the stand, and she indicated this was Detective Furman's voice. These were tapes. She had met him in Westwood in 1985. He became like a technical consultant for her. And Judge, it is chilling, these tapes and what was said by this man in view of what he said here in court. He uses the term dumb nigger, niggers and Mexicans. He uses it throughout. And this is not in any storyline when he does that. He's talking about and giving her background about the LAPD and that sort of thing. I would think the LAPD would be very, very concerned. The title of the screenplay, of course, that she comes up with, Your Honor, is Men Against Women, MAW, this organization that we know, this clandestine organization that we know existed within the LAPD. But having gone through and taken some notes, I wanted to at least make a record, and I want to solicit Your Honor's assistance in something. In addition to using racial epithets and slurs against blacks and Mexicans and women, Detective Furman talks about his philosophy, disagrees with the LAPD philosophy. He shoots to kill, not to stop. He talks about arresting people simply because they're niggers. He talks, Your Honor, if you can imagine, about arresting a person, or stopping a black person in Westwood, and you ask him where he lives, and he says 22nd and Western. The court knows generally where that area is. And then he takes him into custody because he doesn't belong in Westwood. That when he wants to fabricate something to arrest someone, he takes the person's license, tears the license up, and then says, this person has no identification. It is absolutely frightening. He goes and talks about, and this is, you got to understand the time frame. This is near the letter to Kathleen Bell. there was a big concern at the time about feeding people in Ethiopia. And his response is he didn't care at all about feeding a bunch of dumb niggers in Ethiopia. On and on and on. It goes about chokeholds and niggers and on. It's absolutely frightening. And the lawyers for this lady were likewise taken aback. Everybody was. This court would. It is absolutely material because I don't have to remind this court that Mr. Bailey, in his examination, asked Detective Furman, had he ever used that word in the last 10 years? We're within the time frame. And was he as sure about not having used that word as he was about finding the Rockingham glove? You'll recall that. So it's very, very relevant. It's very, very material. 95% or more of what is on the tapes and in the transcripts have to do with Detective Furman and his background, not any characters or not any situation like that. He even talks, if you can imagine, about a lieutenant, a female lieutenant that we heard briefly about, who comes out to investigate Ma in West Los Angeles. And I think the court appreciates the possible relevance of that. We just ran out of time. This judge listened to this and said he'd heard enough. Everybody in that courtroom assumed, along with us, that this was certainly material, this was certainly relevant, that a man's life was at stake. In fact, near the end of the hearing, Your Honor, the lawyers for this lady said things like, we just want Mr. Cochran to make sure she's put up at a nice hotel and perhaps she can bring her husband with her. Everybody seemed to see the relevance except this honorable court there in North Carolina. Now, this is a bombshell. This is a critical bit of evidence for a critical witness in this case. It goes even beyond this case. It talks about a culture. It talks about so many of the things we've talked about. It talks about framing people, setting up people, falsifying reports. And so we need this lady out here. Obviously, efforts are going on to still get her here. We expect to file, if not by this afternoon, by tomorrow morning in Raleigh-Durham, an appeal, a writ of mandamus and a writ of certiorari to the Court of Appeals there. We will go all the way to the Supreme Court. We will go to the U.S. Supreme Court if we have to on this issue. I don't want to delay the proceedings. Your Honor understood the materiality of this, and what I'm going to ask you to consider doing is to give us a declaration regarding the materiality of these tapes, of getting this lady out here to California and in these proceedings. I will be glad to provide Your Honor with hopefully some authority with regard to that. After all, it was your subpoena, and you know these facts certainly better than a judge in North Carolina. And as an officer of the court, so do I. And so justice should not be thwarted by some bizarre decision by a judge in North Carolina under these circumstances. So we're not just going to take it laying down. We're going to move ahead. I have this morning been in touch again with the lawyers for Ms. McKinney. They're also back in California. So with the court, my request then today is to make the record clear of how strongly we feel about this. And how this man, the bottom line is, he's committed perjury. Should be investigated by an office other than District Attorney's Office because of their alliance with this man, perhaps the Attorney General, perhaps the U.S. Attorney. Someone should investigate this for perjury. The Police Commission has to look at this because this whole aspect of everything that took place here, this is frightening and it's extremely serious. And those of us who heard this in that courtroom were chilled by what we heard and what took place. And so what I'm asking the court to do is assist us in getting this information, and I think perhaps a declaration, a further declaration regarding materiality might be the way to go, Your Honor.
All right, Ms. Clark, do you have a comment?
Your Honor, one other thing that I found,
Well, hold on, if they're confirmed.
okay, all right, I'll do it at that point. One other thing that I wanted to say before Ms. Clark started to speak. In one other very, very chilling reference that had nothing to do with any screenplay or whatever, there's a statement with his own voice of the ACLU and NAACP should be bombed. That kind of language, that kind of thought processes, that person who spent 20 years on the LAPD, and I understand he's about to retire, Your Honor, to move to this area in Idaho, is just beyond the pale, and we need your assistance. We're seeking to do justice here. The primary argument of counsel in North Carolina was that, the same argument you've heard here today, that she, as a journalist, she wanted to have some kind of right of privacy and didn't want to divulge this. But it has been divulged. It's clear. We've all heard it, and I think that even the lawyers expected her to be here. Only the judge made this ruling, which we think is entirely inappropriate. And we're asking you to step in and assist us in that regard.
Ms. Clark?
My response is only a legal one. I don't know if this court can really make a declaration based on the representations of counsel, not having heard the tapes yourself, Your Honor. I don't know, legally speaking, what the proper response of this court could possibly be without firsthand knowledge of the material in issue. My review of the transcript to date indicates to me that there was a consistent position taken by the author that this was a screenplay, that Mr. Furman was requested to adopt a character for her in helping her to write this fictional account. This is not a documentary she was writing, Your Honor. It was fiction. And my understanding was that Detective Furman was furnishing fictional material for her as a fictional character. So I think that is important to the consideration of whether or not it's material, and I think the court should know what the matter is before adopting any position in terms of a declaration to oppose another court. That's the only thing I would indicate.
All right, Mr. Cochran, Ms. Clark raises a good point. One, the court issued the subpoenas under the Interstate Compact, and there's a procedure that this court and courts in the receiving states follow. And if the receiving state court made a determination adverse to the issuance of those subpoenas, then there's an appellate remedy, a written appellate remedy available in North Carolina. I've made the determination of materiality here. A judge in a different state has apparently made a different ruling. However, and I cannot in any way criticize that ruling from this vantage point, nor do I think it's ever appropriate for another judge to comment or criticize the rulings of another court, especially in matters that are pending. It's unethical and it's inappropriate. And Ms. Clark does raise the issue that I have not seen a transcript of those proceedings. But you were there.
I was there, and as an officer of the court, I also, someone was kind enough to give us a copy of the tape. Let me indicate this to you. And I will ask the lawyers themselves to come down here tomorrow if you would like to. 95% of what's in these transcripts was not part of the play. This was Detective Furman speaking about his experiences as an LAPD officer, as a technical consultant. This was not any fiction. You think Men Against Women, that's not a fiction. Ms. Clark wasn't there, Your Honor. I was there.
All right, Mr. Cochran, here's the problem, though. The legal issue before the court, is there anything that the trial court here in California has the authority to do to enforce an out-of-state subpoena? The answer at this point, I believe, is no. I've issued the subpoena. It's gone to a reviewing court in another state, and that state has declined to honor that subpoena after holding a hearing. I'm not in a position, I don't think, I don't have any authority or jurisdiction to do anything more at this point, although I will confess to you, this is not a situation that has come before this court before.
It has not, and I'm thinking, Your Honor, about something analogous to extradition situations. And, you know, you made an interesting point, and we're not here to necessarily criticize anyone in another state. Obviously, we've got to go to North Carolina and appeal to another court, so we're not seeking to do that. But, Judge, you know, by this judge taking this decision, by making this decision, he somewhat criticizes your decision regarding materiality. And who, Judge, would know more about materiality in this case that you've been trying since September 26th? You or this judge back in North Carolina. So I just put that in perspective. I think you're being too kind. Perhaps I can say that. I mean, you would not know a lot more, and I don't expect you to criticize your brethren on the bench. But I think that what we're saying, and if I can give you some authority or some assistance, all we're saying is to ask you to give us something that further buttresses what we're talking about. This is not any fiction. This is the way this man lived. This is the way this man thinks. This is when he talks about Hitler celebrations and things like that throughout. And this isn't all of it, Your Honor. There's like 12 hours up until the time after he investigated these particular crimes that this thing went on. It is absolutely frightening. And what it is bottom line, it's perjury. It's absolutely perjury. He didn't claim any exception for anything. And that's what it boils down to. This cannot be allowed to stand. And so I'm really frankly surprised that Ms. Clark would even say anything. When we talk about a search for truth, this is the truth. We got his own voice, not anything anybody made up. It's his voice, his words. And so I think that if you would even just reaffirm your finding of materiality in light of these facts on the tapes. I mean, I think that's what we need, and I want you to give you some time to think about it. We want to get back to the jury. You'll think about it and then not rule at this point. You're never precipitous, and you wouldn't be now. And think about it, and let me see if I can provide you with something additional. Oh, after all, we're talking about your subpoena that they failed not to give. I didn't have a subpoena. It was yours, Your Honor. And so from that standpoint, I think we have an interest in doing the right thing here, being honest and pursuing the truth.
But, Mr. Carrigan, we have to put this into perspective. While I have the benefit of having sat through this trial every day since June the 22nd, so I know something about the facts and circumstances, that court heard the tapes, saw the transcripts, and talked to the parties involved, the author and her counsel. So that judge has more information than I do about the particulars.
Well, let me say this.
I decline you will not lure me into criticizing another judge.
No, and I'm not trying to get you to criticize anyone. I'm just saying I have a copy of the proceedings, so you can see those very easily. Let me tell you something, Judge. We went back into chambers for about maybe a half hour, and we read transcripts of the first 48 pages that talked about framing people and that sort of thing, tearing up a license, what you do for this. We read this, and we then listened to enough of the tape and then brought the client in to say, is that Mark Furman's voice? And of course it was. You got to understand, this happens from 85 up to 94. 90% of the information we never heard. But in talking to the lawyers who had heard this, they were very clear. It's nothing to do with any screenplay. This was background. There's perhaps one or two references about a screenplay. She then took what she wanted from him as a resource person. In fact, she talks to another police officer, too, somewhere on these tapes. This is far more to this than what the prosecution is aware of. This is a situation where these tapes ultimately must come to California, Judge, because it's critical to the defense. And as I said, we're going to take this all the way to the U.S. Supreme Court if she doesn't come forward voluntarily. But it's not, they cannot hide behind an absence of materiality. And I don't want you to criticize anybody. I just want you to stand up for what you believe. You know that Furman is material, as I've indicated. If the jury disbelieves his testimony, Your Honor, who could quarrel with the fact that's very important on this particular case, where he's committed perjury? And so that's what we're talking about here. So I'd like an opportunity to perhaps see if there's any cases that might assist us, anything analogous to this in the law that will help us.
All right.
And but I wanted to bring it to Your Honor's attention at the first available time.
All right. Thank you, counsel.
Thank you very kindly, Your Honor.
All right. Are we ready to proceed? All right. Deputy McNair, let's have the jurors, please.
Reminded to save time, I'll finish my direct in probably 10 minutes. The court had already ruled that before the prosecution can begin its cross-examination, they have to turn over for disclosure the impeachment material they intend to use before they begin the cross. In particular, transcripts of any other proceedings they intend to use have to be given to counsel. And also, Your Honor, it's my understanding that we agreed that before they go into any other cases, that we will have a sidebar on those issues as well.
That's correct.
Thank you. Minutes is going to be a brief recess to deal with some of those issues. Okay.
And Professor McDonald, would you resume the witness stand? Record should reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. All right, good afternoon, Professor.
Afternoon.
You're reminded, sir, that you are still under oath, and Mr. Neufeld, you may continue.
Thank you, Your Honor. Good afternoon, everyone. Professor McDonald, you may recall this morning I asked you a couple of different hypothetical questions. Let me begin by asking you another hypothetical. Sir, based on your observations of the sock and your expertise, are the wet transfer stains that you observed on the ankle area of sock 13A consistent with someone dabbing the sock with blood after it has been removed from Mr. Simpson's foot.
Objection, Your Honor, objection. It's only on the school's expertise and speculation, improper
Rephrase the question. Rephrase the question, counsel.
Hypothetically, sir, and based on your examination of the sock, and based on your 4 years of expertise in interpreting bloodstain patterns, are the wet transfer stains that you observed on the ankle area of sock 13A consistent with someone dabbing the sock with blood after it has been removed from Mr. Simpson's foot and spread?
Sustain. Problem is removal while it's not being worn.
Okay. You want me to rephrase it?
Yes.
Okay. Based on your observation of the socks and based upon your 40 years of experience in this field, sir, are the wet transfer stains you observed on the ankle area of sock 13A consistent with someone dabbing the sock with blood when it is not being worn by Mr. Simpson and instead spread out and laid flat on a flat surface?
Overruled.
Yes, they are. The stain is, I should say.
Okay. Now, I believe you testified earlier, last week, when we started the direct examination, Professor, that the ankle stain, even that portion of the ankle stain that's remaining, was visible to the naked eye when you examined it on April 2nd. Is that correct?
That's correct.
Now, you're a trained criminalist. Is that correct, sir?
Yes?
All right. In your expert opinion, sir, should other trained criminalists be expected to visualize the blood stain on the ankle with the naked eye?
Yes, they should.
All right, now let me ask you
Overruled.
one last hypothetical, sir. Assume that on June 29th, 1994, 3 criminalists from the Los Angeles Police Department laboratory, Greg Matheson, Laboratory Director Michelle Kessler, and Colin Yamauchi, removed the socks from their packaging and laid them out on a white sheet of paper to inspect them. Given what you observed on April 2nd, would you have expected the trained criminalist on June 29th to discover the bloodstain on the ankle had it been there on June 29th?
Objection. That calls for speculation,
No.
improper hypothetical, seems facts, not evidence.
Sustained.
You- Are you aware of the fact, sir, that Greg Matheson and Colin Yamauchi testified that on June 29th, 1994, they took the socks out of its packaging and examined it on a white sheet of laboratory paper?
Objection, Your Honor, it seems facts, not evidence, calls for speculation.
I have the,
Sustained.
I have the
Sustained.
transcript.
I know what they said, counsel. Problem is examined, is the word examined. It's a vague term in the context of this question.
All right. Are you aware of the fact that Colin Yamauchi and Greg Matheson testified that on June 29th, they removed the socks from their packaging and placed them on a white sheet of laboratory paper?
Yes, I have read that.
Okay. Are you aware of the fact, sir, that they testified that they looked at the socks at the time that they removed them from their packaging and placed them on a white sheet of paper?
Objection, objection, that states the testimony.
Overruled.
Yes, I am.
Sir, given those facts, would you expect that those trained criminalists would be expected to have observed the blood stain on the ankle that you observed on April the 2nd?
Objection, that calls for speculation, argumentative.
Overruled.
Yes.
Now, right before lunch, I asked you some questions about body temperature. Do you recall that?
Yes, I do.
And I also asked you some questions, sir, where I asked you to literally read from the official records of the U.S. Weather Service. Do you recall that?
Yes, I do.
Now, you're not a meteorologist, are you?
No, I'm not.
You're not an expert on weather conditions, are you?
Well, as a layperson, yes, but not as an expert.
Okay. But you're able to read numbers off of this sheet, are you not?
Yes, I am.
And when I say this sheet, I'm referring to, I think,
1280.
1280, the official records of the U.S. Weather Service. And, sir, when you read those numbers, it revealed that the temperature range between the evening of June 12th and the morning hours of June 13th were between 63 and 66 degrees. Is that correct?
That's correct.
When earlier this morning you were talking about the different factors which can affect drying time of blood, does temperature affect drying time?
Certainly.
Will a stain dry faster at 90 degrees than at, say, 64 degrees?
Objection, no foundation.
Overruled.
Yes, it certainly will.
No further questions, Your Honor.
Ms. Clark. Oh, I'm sorry. All right, let me see counsel over the sidebar. With court order. Ms. Clark.
Good afternoon, Mr. McDonald.
Afternoon, Mrs. Clark.
Good afternoon, ladies and gentlemen. Mr. McDonald, you indicated that you've authored many articles, correct?
Yes.
And you've written a book that has since recently been revised, is that correct?
Yes, it's been revised twice, actually.
And the last revision was in 1993, is that correct?
That's correct.
Now, there was a paper that you presented, sir, as recently as earlier this year in Seattle, is that correct, entitled Absence of Evidence is Not Evidence of Absence. Do you recall that?
I believe Mr. Kish presented it. I co-authored it with him.
Yes, you are listed on the article as the co-author, were you not?
Yes.
All right, Ms. Clark, I'm going to direct you to give a copy of that to Mr. Neufeld.
I'm going to show you a copy as well, sir. Mr. Kish is entitled in this article as your research associate, is that correct?
That's correct.
I'll show you the article, sir, and ask you if you recognize it.
Well, this is the article. It's not been published yet, but it's basically the same thing. I hope it'll be published in this form.
That is the form in which you intend for it to be published, is that right, sir?
That's correct.
And you have presented this paper at a number of speeches that you've given, is that correct?
No, I've never presented it. Mr. Kish presented it in Miami in September last year, basically the same thing.
Nevertheless, sir, I suppose you would agree that you, even though he presented it, you co-authored it, and you stand by the principles that it espouses, correct?
Oh, absolutely.
And in that regard, sir, with regard to this paper, I want to ask you a series of questions concerning the contents. First of all, I'm going to direct your attention to the first page, the third paragraph, sir. I'm going to display it to you.
Yes, with court order, please.
All right, sir. As a general proposition, would you agree that the absence of bloodstains on a defendant or his clothing, which are frequently assumed to be definitive evidence that the defendant did not directly participate in the violent act, is a common misconception that is fostered and exploited by those who have insufficient knowledge and experience in bloodstain pattern interpretation, or by those who hope to help in their client's defense? Would you
Yes.
agree with that, sir?
Yes, I would.
Oh,
And that is the subject matter of this article, is it not?
Basically, it's a law school theme. It's not original with us. We just applied it to more specific applications in bloodstain pattern interpretation. It's a general rule, yes.
And as a matter of fact, the absence of blood, even in a very bloody crime scene, the absence of blood on a defendant or his clothing is not an unusual thing in your experience, is it, sir?
sustain.
With regard to the amount of blood you expect to see on a defendant or his clothing after having committed a very bloody crime, a stabbing such as this one, if you were to fail to see a great volume of blood on that person, would that be surprising to you, sir?
Sustain.
The view that blood, the absence of blood on a defendant who has participated in a bloody crime is not unusual. Is that one widely held in the forensic community?
Sustain. Sustain.
Sir, you found, you examined these two socks, correct?
Yes, I did.
And you found the one stain which you quantified as being one drop, is that right?
Yes.
In the context of your examination, sir, and based on your experience and your expertise, is it unusual to find such a small amount of blood on the clothing of a defendant who has just involved himself in a very violent act, as you found in this case?
Objection again, Your Honor, assuming facts not in evidence. No
Sustain.
testimony.
Rephrase the question.
You examined both socks, correct?
Yes, I did.
And you observed blood, is that correct?
I observed what was tested to be blood. I didn't actually do the testing, but I observed some of it being tested with presumptive tests.
Okay. Other than, well, with respect to the blood stains that you found on the socks, sir, you found the one stain at the bony ankle area that protruded, correct?
Again, I did not determine they were blood. If they were blood stains, the stains I found were on more or less the bony protuberances, yes, the ankle bone.
All right. Now, the cutout area, the actual stain itself was cut out of the sock when you saw it, correct?
The center was cut out, yes.
And did you examine that center at any point?
The cutout wasn't with the sock. I never saw it, no.
Yeah. So all you ever saw was the periphery, correct?
The periphery and the cutout area.
The periphery of the cutout area, sir? Is that what you're
The
saying?
periphery of the stain within which the cutout area existed.
Okay. And then the area that was actually removed from the sock, that cutout, you did not see.
No, I did not.
So you did not see the center of the stain, is that right?
That's correct.
Now, with respect to the amount of blood on those socks, did you characterize, or what might be blood, okay, the amount of staining that you observed, did you characterize that as heavy staining, sir?
In the area, as you came closer to the cutout area, it became more concentrated. I would not say it was terribly heavy, but it certainly was saturated in some areas. But the overall size of the stain would not tell me it's a heavy staining. It's about what one drop would do. The center would be wet through, and as you go out to the edges or the periphery, it becomes less and less to the point where it's just on the surface, the outside surface of the fibers.
Now, have you seen photographs of the crime scene in this case, sir?
Some of them.
Okay. It was a very bloody crime scene, was it not?
Objection on beyond the scope.
I've seen photographs of the crime scene, yes.
And would you agree with me, sir, that it was a very bloody crime scene?
It was an extremely bloody crime scene. I've seen several that were bloodier, so to speak, but there was a great abundance of blood, yes.
Okay. In your experience, sir, this is you've seen other double homicides, is that correct?
Yes, I have.
And so this is a double homicide. You've seen that before.
I have.
And you've seen, I'm sure, cases in which there were throat slashing with maybe some arterial splurt, have you not?
Yes, I have, many times.
In fact, isn't that the subject of some of your discussions in your book?
Yes, that's one of the classic patterns. It's arterial gushing. There are 3 subdivisions, but that's a classic pattern.
Okay. So that would not be unusual as an aspect of this case, correct?
Objection on beyond the scope.
Sustained. Let's go back to this sock, please.
Yeah, I'm trying.
I know what you're doing.
You know what? Okay.
Proceed.
In other words, the amount of blood that you see in this crime scene, you have seen before, not unusual.
That's correct.
And the aspects of this killing are not unusual in your experience. You've seen them before, correct?
That's correct.
All right, now,
Roll.
and you examined the socks, did you not, sir?
I did.
And you indicated before, when I just asked you a couple of minutes ago, that the amount of staining on the socks was not terrific, although in one area it was more concentrated, correct?
That's correct.
Is the absence of a great large volume of blood on those socks a surprise to you, in your experience, sir, based on what you know about what you expect to see on a defendant who has committed a very bloody crime?
Objection again, since facts not in
Phrase
evidence.
the question, please.
Based on your expertise, sir, and your experience over the years, is the failure to find large glops of blood on those socks unusual in light of the fact that there was a great deal of blood at the crime scene?
Again, objection since facts not in evidence. There's no testimony.
Roll.
No, it's not surprising at all because there's one basic thing that I don't know, and I don't think anyone does, that if a person is wearing long pants, it would cover that area. If they're wearing shorts, it wouldn't. That would be one thing that could intercept blood if it were indeed projected toward the socks. If I stand up, my pants will cover my socks, but not while sitting down. So that's just one factor. There are many factors to consider. And the absence of a lot of blood staining doesn't surprise me, but the presence is what we examine. We speculate on what's not present.
And that is something that you have warned many others not to do, isn't that correct?
That is correct.
That you should interpret what is there and not speculate what is not there.
Correct.
And so the absence of blood on a defendant who's committed a very bloody crime is not a surprising thing to you in your experience.
Sustained. Talking about socks.
The absence of a great deal of blood on those socks is not a surprising thing to you given your experience and your knowledge in this field, correct, sir?
No, not surprising.
And there can be innumerable explanations for that Wouldn't you agree, sir?
Yes, there can be.
Now, in your exam, did you only examine the socks in this case, sir?
That is correct. There were, I think, shoes or boots, but the only thing that I particularly examined was the two black socks, or navy blue, I should correct that. I see it as black. My wife sees it as navy blue. I don't think there's a difference.
Okay. So that was really the limit of what you examined in this case?
Yes, as far as the physical evidence is concerned.
Sir, can you tell us what are medium velocity blood spots?
Well, I don't know. We talk about blood spatter that results from medium velocity impact. If you're referring to that, they are projections of blood that results from an impact that may be consistent with a beating, a stabbing, any kind of action of approximately 25 feet per second, which is a very arbitrary value.
And when you say stabbing, I assume you would also include in that a throat slashing.
No, that would not be the same as a stabbing. A stabbing is simply a beating with a sharp instrument. And the spatter that results is from the impact to the surface where blood has accumulated. A slitting of an artery would produce no medium velocity. It would produce arterial gushing. It might produce some cast-offs, but unless you did it very rapidly, you couldn't have medium velocity spatter from a slitting of a throat, for example.
From a slitting, but that assumes, of course, that the perpetrator is standing in front to get the gushing or the spatter onto them. If he's standing behind, that would not be the case.
Well, again, that's not spatter. That would be arterial gushing. And it's less likely you would get blood coming from a wound to the front of a person if you're standing behind them than if you're standing in front of them. I think that's basic logic.
Now, what kind of what velocity of spatter would you expect to see on the perpetrator of a crime who stands behind his victim and slashes his throat?
Sustain. Sustain.
Do you recall, what would you qualify? You indicated that you saw some evidence of spatter on the socks, correct?
Objection, that was testimony.
Yes, it was. I have the transcript.
Phrase the question, please.
You testified on direct that you saw some evidence of spatter on the socks. Do you recall that testimony, sir?
I don't believe I said I saw spatter. I saw what had been described as spatter. If I said I saw spatter, I did not see what I would call blood spatter.
Yes.
I'm going to show the excerpt to counsel, and then I'm going to read it to you, sir, and see if that refreshes your memory. Sir, I'm going to direct your attention to this area right here and ask you to read it. and ask you if it does not indicate that you said that you had seen other more convincing evidence of it, referring to spatter.
I can't listen and read at the same time. Yes, I've seen more convincing evidence of spatter in my career, but not on the socks.
I think that you ought to continue reading, sir.
Again, I'm referring to blood spatter as it appears, not on the sock. I looked at the best photographs available to me were the infrared pictures. They are not small round circles of what could be blood or something else. I think that's slightly out of context, but I can see how you would interpret it to mean on the socks.
Well, let me read this entire thing to you, and you tell me how you interpret it, all right, sir?
Certainly.
You were asked by Mr. Neufeld in your opinion, Professor McDonald, is the ankle stain that you saw a spatter stain? Your answer? Not based upon the examination that I made of the socks at that time. I did not find any distribution of blood that I could consider a spatter. I have seen other more convincing evidence of it. Mr. Neufeld, okay. Now, with respect to the ankle stain, I want you to focus on that. In your opinion, was the ankle stain a spatter stain? Spatter stain, excuse me. Oh, no, not the ankle stain. I thought you meant the entire stocking. Now,
Yes,
can you explain to us, sir? Well, let me ask you this. Didn't you mean to convey by that in examining the entire stocking, you had seen evidence of spatter? Isn't that what you meant to convey?
Not at all. I stated that I've seen more compelling evidence of spattering many times than anything on this stocking, particularly in his first part of his question relating to the small transfer stain. Then when he went to the other spots, I disagreed. That is not what I'm referring to. I've seen more on other objects than I have on that sock. That is, the way you're reading it, it would sound like I'm referring to the socks, but the evidence I've seen does not show spatter on the
Sir,
socks.
excuse me, but isn't it what you said here? You didn't say that in response to Mr. Neufeld's question. You said,
Wait. Counsel, rephrase the question. That's argumentative.
what you said in response to Mr. Neufeld's question, sir, was, oh no, not the ankle stain. I thought you meant the entire stocking. Were you referring to a stocking in another case?
No, I'm referring to that stocking, and I have seen more compelling evidence of spatter than I have ever seen on that stocking. That's not spatter.
Did you see any evidence of spatter around the ankle stain to which you've testified?
No.
You saw none.
Nothing that I would say makes a pattern of spatter. You don't have one little spot or two making a pattern.
And yet, sir, you have testified to a few little microbes as a pattern, have you not?
No,
You have testified concerning your observations of one stain, isn't that true?
that's correct.
And in your book and in your writings, you have previously said that one stain does not a pattern make, isn't that correct?
That's correct.
But in this case, you've testified to only one stain, isn't that right?
I'm testifying about the mechanism and not a pattern. A pattern consists of more than one stain. A mechanism of how it got there is an entirely a different matter.
What is the other evidence of blood that you saw around the ankle stain to which you've testified?
What's the other evidence?
Yes, what other pattern did you see, or what other spots did you see around the ankle stain that caused you to make the statement that you did concerning the observation of the entire stocking?
That I didn't see any spatter on the entire sock as well. I've seen more compelling evidence of spatter. The person who looked at that and thought they were round spots is mistaken. They're not spatter. They look
What is
like
it?
flying saucers and donuts and trapezoids. They're
What is
not
it?
round.
What is it?
Your Honor, objection, please allow the witness
Yes.
to finish her 9
I'm sorry.
Yes.
Well,
Then
that-
what is it?
I don't know. It looks like it was transferred in an irregular fashion. I don't know the mechanism.
You're testifying now to the finer spots around the ankle stain?
No, I'm testifying to the overall socks.
Sir, I'd like you to talk about the spots that are around the ankle stain to which you've testified. Can you do that for us, please?
Yeah?
Okay, can you tell us what your observations were with respect to the areas around that ankle stain?
I don't recall exactly. There might have been other spots there, but the stains immediately around it that were disassociated are on the surface of the fibers. They're the transfer stains.
You indicated, sir, that you saw the infrared videotape of those socks, did you not?
Yes, I did.
And would it refresh your memory a little bit if we showed you that infrared videotape?
Yes, I think photographs would be better because they're static, but I'll be happy to look at it again.
Thank you, we'll get those. Now, you indicated in your book that medium,
I'm sorry, I would ask that the attorney state which book, because there were several.
Which edition? Third edition? Just show Mr. Neufeld the page you're referring to. And which page, Counsel?
62.
62. All right. All right, proceed.
All right, in your book, sir, you talk about the fact that stabbing or cutting will generally result in medium velocity bloodstains, correct?
Yes, if there's sufficient impact.
And then you indicated in your book that medium velocity blood spatter is difficult to see. In fact, you said in your book that when such medium velocity blood spots as are generated in a stabbing are discovered on the clothes of the killer, they will usually be somewhat below the resolution of the average juror's eyesight. Can you look at page 62 and tell us if that is written in your book?
Yes.
And then that difficulty is enhanced or made more difficult when the material is dark in color. Isn't that true, sir?
That's correct.
And in fact, you had difficulty in the visualization of blood spatter on dark clothing in the Briggs case, in which you testified in Monterey County.
Wait. Let me see counsel at the sidebar. No, not at this point.
Counsel has it, Your Honor. That's
I understand he has it. I haven't heard a basis for its admissibility yet. Proceed. The issue is the ability to see blood staining, medium velocity blood spatter on dark clothing. That's the issue. Proceed.
All right, and you would agree, sir, that blood, especially of the medium velocity range, would be difficult to visualize on dark fabric, isn't that correct?
Generally, yes.
And what is the size of an average blood drop, sir?
50 microliters is the volume. If you want the diameter, it's 4.6 millimeters in air.
In air.
Yeah.
And on impact?
6.4 millimeters diameter. If it's very carefully laid down, in all practical purposes, if it falls perhaps 6 or 8 inches, it will be up to 11 or 12 millimeters.
Okay. And what was the size of the stain that you measured on the ankle bone of the sock, the ankle bone area of the sock?
There was no specific drop or circle. It was smeared in a sense. That's why it was not uniform in its density. The overall size was about 1 by 1.5 inches.
And you estimated then that the amount of blood in that stain would have been how much?
About 1 drop, possibly a little more.
50 microliters?
50 microliters, 60 microliters. It's very difficult to tell because the surface itself is plastic, that is, it's synthetic. And so it smears more easily than, say, cotton or something that would absorb more readily or thicker.
Did you take the material of these socks and attempt to measure the absorption rate on these socks?
No.
Did you make a cutting from the material of these socks and attempt to evaluate how much blood would actually be absorbed in the area of the size of the stain to which you've testified you think this one was?
It wouldn't have mattered if I had it. No, I didn't cut one out, but there's no way I could design such an experiment.
But your answer is no, you didn't.
No.
And did you perform any experiment on the actual socks themselves by cutting out a swatch to determine how absorbent it would be of water, how quickly it would absorb water?
No.
Did you cut out a piece of this material from these particular socks and imbue them with blood to determine how readily they would absorb blood?
No, I did not.
Wouldn't you agree, Mr. McDonald, that it would be of some assistance to you in your testimony to have known how readily this particular sock would have absorbed blood or water?
If it was possible to determine it, I would be able to give a more accurate estimate, but I cannot think of how to design an experiment to do that. If it comes from something other than a medicine dropper or a pipette, in other words, from a fingertip, I don't know how to measure the volume on the fingertip before I touch something and then measure the volume that remains, the difference being what's transferred.
Well, let me ask you this, sir. You examined the sock, and you saw only the periphery that had not been cut out, correct?
That's correct.
And you never examined the piece of fabric that was the center of the stain, correct?
That's correct.
Wouldn't it have been of some assistance to you, sir, to look at the inside, the center of that stain, in making your estimate of how much blood was actually in it?
I don't believe so, no. The stain was as saturated as I believe it could be right up to the outside of the cutout portion. If you're going to suggest the center was in some way void, then that would have been interesting. But I think they cut it out because it was the heaviest stain to do their testing on.
You think, but you don't know.
Well, it'd be pretty stupid if they took a void.
You didn't look at the actual stain itself, did you, sir?
Of course not.
And so what you're telling us, when you're telling us what your estimate is of the amount, is your best guess. Isn't that right?
It's an educated guess based upon experience, yes. It's a
Nonetheless.
guess. It's an approximation.
A guess.
Estimate.
You did not quantify the blood in that stain, correct?
Yes, I estimated it to be about 1 drop, possibly a little more.
What test did you do, sir, on the inside center portion which you never saw? What test did you perform on that center portion which you never saw to determine precisely how much blood there was in it?
I assume that physics works in California and
Objection,
capillary
Your Honor,
action.
this is non-responsive. The question was...
No, the question, I'm going to sustain the court's own objection to that question. Rephrase the question or move on.
Did you conduct any experiment to quantify the exact amount of blood on the cutout portion of the stain?
No.
did you conduct any experiment to quantify the amount of blood in the periphery of the stain that remained on the sock?
No tests, no.
Now, you examined those socks for the first time on April 2nd, 1995, is that right?
That's correct.
And present with you at the time of that examination were Mark Taylor and Henry Lee, both experts for the defense, correct?
Yes, and there were other people present, of course.
During your examination?
Yes.
And who was that?
Peter Neufeld, and I think it's Greg Matheson. He had custody of the evidence.
Greg Matheson had custody of the evidence. He brought it to you, is that correct?
I believe he was there all the time we examined the sock. He stepped out, I believe, at a point when we had shoes out or something like that. He wasn't there all the time.
Isn't it true, sir, that you requested that he leave while your examinations were being conducted?
No, that isn't true.
Objection, no foundation.
Overruled.
No, that is not true.
You did not permit him to remain in the room the entire time you were performing your experiments and your investigation. Isn't that correct?
Objection to compound question.
Overruled.
No, ma'am, that is not correct. I was not giving orders or requests to anyone. I was there to make examinations. What went on between other people, why they came in, why they left, was of no concern to me. I did not direct such things, no.
Someone in the room did ask him to leave at some point, did they not, sir, in your presence?
I don't remember it. I know he left. I don't know if he was asked to leave or he had to go to the bathroom, but he wasn't there all the time.
And he left for a substantial period of time, did he not, sir?
Objection vague and substantial.
Sustained.
All right. He was gone for over an hour, was he not?
Objection, no foundation.
Overruled.
I don't believe he was gone anywhere near that long, but to be honest, I was paying no attention. I was examining things, and whether he was there every minute or not, I don't know. I do recall he left for a period. I don't know how long it was.
Let's move on.
Then it's your testimony that you do not recall anyone asking him to leave the room. Is that the way you remember it, sir?
That's the way I remember it.
Overruled.
All right. Now, with respect to those socks which you saw for the first time on April 2nd, 1995, sir, would you please tell us your understanding of the history of those socks from their date of collection on June the 13th, 1994?
My understanding is that they were kept in custody. They were tagged in and out. I really didn't inquire as to the history.
Sir, wouldn't you agree that it would be extremely important to know as much as possible about the life history of those socks and how they were handled before you saw them?
Objection as to what purpose?
Sustained. Question's vague. Phrase the question.
For the purpose of determining or assessing that what you saw was the condition of the socks at the time that they were collected on June the 13th, or at the time the blood was first detected at some point thereafter. Wouldn't it be important to you to know what those socks had been subjected to between the time of their collection on June the 13th and some 10 months later when you finally saw them on April 2nd, 1995? Wouldn't
Objection
that
as
be important to know?
sorry. Objection as to word condition is too vague.
Sustained. Rephrase the question.
Sir, with respect to whether or not those little balls, those little microbes, were on the opposite inside surface of the sock, which you observed.
Sustained. Sustained. Counselors, not microbes.
What did he say?
You
He didn't
said
say that?
microbe. You've used the term 3 times now, microbes.
Those little balls that you testified to, sir, on the opposite inside surface of the sock, wouldn't it be important to you to observe the condition, to observe whether or not they were present when the sock was collected on June the 13th or at the time the blood was detected thereafter, to know whether or not that condition existed at that time, as opposed to when you finally saw them 10 months later, April 2nd, 1995? Wouldn't it be important to you to know what had happened to them in between those two times?
It wouldn't be important to me. I examined them to see what was present. Unless there's some strange handling of the evidence or storage, that's something I would not know and would expect to be documented in some manner and be advised of. But that's more for the attorneys to establish Then when I'm asked to examine something, that's what I do. I don't know the history of it.
Oh, sir. Then it's your testimony that no, it would not be important for you to know all of the handling and what had happened to those socks from their time of collection till the time you examined them for the purpose of giving more meaning to your observation of those little balls.
I believe I answered that and said it could be important, but I do not know what it was.
You do not know the history.
That's correct.
Then you agree that it could be important for you to know that.
I just said that.
Then wouldn't you also agree, sir, that it would have been important for you to observe the condition of those socks, at least as of the date when the blood was first discovered?
If they were altered from the time they were discovered until I saw them, yes. If they were kept in pristine condition, no.
Sir, and that's my question. Wouldn't it be important to know whether they had been kept in pristine condition or tested, manipulated, twisted, and bounced around? Wouldn't it be important to know that if that occurred in between the date of collection or blood detection and your observation?
It might explain what I saw, but it wouldn't change what I saw.
I agree, sir, but it might help to explain what you saw, would it not?
I'm not explaining what I saw from the standpoint of the history. I'm explaining the appearance as I saw it.
And so you cannot tell this jury that those little balls that you saw on the opposite inside surface were there when the sock was collected on June the 13th, can you?
Sustained. Raise the question.
Sir, you cannot tell this jury how those little balls came, strike that. You cannot tell this jury, sir, when those little balls came to be on the opposite inside surface where you observed them on April 2nd, 1995. Isn't that true?
No, I can tell that.
You can tell them when?
Yes, it was before I examined them.
Yes. At any point before they examine them, though, you cannot be more specific than that. Isn't that right?
That's correct.
And you cannot tell this jury that those little balls came to be on the opposite inside surface on June the 14th, June the 15th, August 10th, September 28th, or any other date, specifically before the date you examined them on April 2nd. Isn't that right?
Objection, facts not in evidence, there's no good faith basis for the question.
You can answer.
I'm sorry, I didn't hear. No, I have no idea when they occurred. They occurred prior to my examination.
Make any effort to inquire of Greg Matheson as to the history of the socks when he was present with you on April 2nd, 1995?
No, I did not.
Your Honor. Now let me ask you something. Are you aware that phenolphthalein tests were conducted on this sock on August the 4th, 1994?
I may have read that. I don't recall that date specifically. I know phenolphthalein tests were performed.
All right. And there are two types of phenolphthalein tests, correct? Well, maybe more, but
Well,
at least two.
Phenolphthalein is reduced to phenolphthalein. When it reacts with peroxidases, it converts back to phenolphthalein. It seems few people can spell the word correctly, but there's a test with phenolphthalein.
Oh.
Very sensitive for peroxidases in blood.
And
You asked the question.
Well, I should have called him way back when. Anyway, Mr. McDonald, let me ask you, are you aware that there are some phenolphthalein tests that are wet in nature, that require the use of diluted water? Excuse me,
No,
not diluted water, distilled water.
diluted water. I've seen it written both ways, but I think most of the tests that I read about recently are orthotolidine, not phenolphthalein. Orthotolidine, I believe, is what was used when I was there.
Okay. Which is a dry method, is that correct?
Well, the material that you're testing is dry, and you use a moistening agent, piece of damp filter paper or something, to remove from the surface some of this material you're testing. And then you use wet reagents. So it's dry then wet.
Are you aware of the kind of phenolphthalein test conducted on August 4th, 1994?
Excuse me, Your Honor, objection to this for the sidebar. I believe there's no evidence of this at this point.
All right, I think we'll take our break with the jury at this time. Ladies and gentlemen, we'll take our mid-afternoon break at this time. Remember all my admonitions to you. And I'll ask you just to step back into the jury room, and we'll get back to you in probably about 20 minutes this time. Going with this?
I want to show him the photograph.
Now, where are you going with this? What's the point of discussing phenolphthalein or phenolphthalein testing with this witness? All right, Mr. McDonald, why don't you step out of the courtroom, please? Where are we going with this?
The point is the alteration to the socks, Your Honor. There's been a lot that's been done to these socks. This is one of the things, and they used water on the stain, and the water is observable in the photograph.
The water is observable in the photographs that were taken by the defense.
No, by the people. The stain was rehydrated, is what I'm saying. This was a stain in which there's confirmed testing, so we're not running up against the court's ruling concerning phenolphthalein, if that's the counsel's concern.
No, I was wondering, no, I wanted to know where we're going with this. That's what I wanted to know. All right,
That's-
Mr. Neufeld?
That's where we're going.
Are you saying that the inner surface of the opposite side of the sock was tested after a section was cut out with the wet phenolphthalein test? I'm just trying to seek some clarification here. Or are we simply talking about that the stain on the outside of the sock where the stain was originally found, if you will, had a phenolphthalein test?
First time I've heard of rehydrating a blood stain.
You see?
I'm sorry.
But what was the purpose for rehydrating a blood stain?
No, they didn't rehydrate purposefully. It was in the course of the test, using the distilled water. The stain was rehydrated in the
Okay.
process of trying to test it. This is August 4th. They're testing the outside of the sock.
Was this before the cutout was made?
Yeah.
And so it's not on the other side of the sock.
No.
But I think her point is going to be if it's lying flat, that could explain how the substance is on the inside of the opposite side.
Well, this is one of many possibilities. This is one. I mean, there's been a lot done to this sock that he doesn't know about. And it's important, as he acknowledged, that all of the history of this sock and what was
Right.
done to it is important.
Okay, now you know.
Okay.
All right, we'll take 15. Doesn't matter, all parties are again present. Deputy Mayor, let's have the jurors, please. We're going to go to 4 o'clock. And I hope we will conclude before that.
Your Honor.
All right. Important things to do next week. Mr. McDonald has important things to do next week. His son. Well, by Friday. No, I'm saying we'll finish today. Yeah. Ladies and gentlemen, please be seated. Mr. McDonald, would you resume the witness stand, please? And Ms. Clark, you may continue with your cross-examination.
Thank you, Your Honor. Now, when we left off, sir, we were discussing the fact that you were not aware of the history of the sock before you saw it on April 2nd, 1995. Do you recall that?
Objection. I didn't say the history.
No, I do not know the history prior to that, how it was stored and maintained, no.
And you made no effort to determine what the history of the sock was with respect to how it had been handled before you saw it on April 2nd of 1995.
All right, we've established that already. Let's proceed.
I think I only asked about Greg Matheson. I would like.
Let's proceed.
Well, can you tell us, sir, what effort you made to determine what the history of the handling and testing of that sock was before you saw it on April 2nd, 1995?
I did not make any determination of the history. My purpose there was to examine it as it was, in the condition received.
In that case, sir, then you cannot tell us whether the condition you observed on April 2nd was there before August 4th, 1994.
No, of course not.
Ms. Clark.
Yes, Your Honor. I'd ask that this photograph be marked People's next in order, People's
553.
553.
Appears to be a photograph of a sock with a Q-tip.
You recognize what's being done in this photograph, sir?
Yes, I do.
That's a phenolphthalein test, isn't it?
Well, it's the sampling prior to the phenolphthalein test.
Yes, and the phenolphthalein test is a presumptive test for blood, is it not?
That's correct.
Now, if you would focus in, Jonathan, on that thing. Do you see that spot there, sir?
Well, I did.
Used to. You see it?
I see, yeah, there it comes. I see a spot, yes.
All right. Does that appear to be water, sir?
Objection, Your Honor.
Sustained. Sustained.
Does it look wet?
Objection, Your Honor.
Sustained. Sustained.
Appear wet?
Yes.
What does that look like to you?
It looks like a yellowy lips.
And does it look like it might be liquid?
Objection, Your Honor.
Sustained.
Is there a form of phenolphthalein test that uses distilled water, sir?
Yes, certainly. You have to have a solvent, either saline or distilled water.
And if that is the test does that appear to be the test being performed here, sir?
Objection, Your Honor. That's what appears.
As stated before, it appears to me to be the sampling phase. First you sample the material and then you analyze it by adding the reagent to it. This would be just sampling, removing a suspect stain or a portion thereof for testing.
Okay, and you remove the suspect stain or a portion thereof by using a damp Q-tip to sample the area, is that correct?
That's correct. A damp Q-tip or whatever, filter paper you can be used also.
Okay. In this case, they used what appears to be a damp Q-tip. Would you agree, sir?
I would agree it's a Q-tip, and it apparently has been damped. It should be if it's going to be used.
Now, are you aware of the date on which this photograph was taken?
No.
Now, sir, would it be important to you to know whether, as of the date, after the date of this photograph, assume for the hypothetical that it's August 4th, 1994,
Objections to no evidence as to when this particular picture was made.
that the socks were frozen and unfrozen, twisted, cut,
Objection as to twisted.
Sustained. Rephrase the question.
An objection as to cut.
Overruled.
At this point,
Overruled.
would you agree, sir, that it would be important to know that after the point of the testing shown in this photograph, the socks had been frozen and unfrozen repeatedly? Would that be good for you to know?
Well, again, this is not testing in the photograph. The test followed the photograph. It would not be important for me to know because I saw what I saw at the time I examined it. If you want me to speculate as to what could have caused it, then if I knew certain factors, I might be in a position to speculate.
Then you would agree, sir, that your lack of knowledge as to whether or not the socks have been frozen and unfrozen repeatedly would have an impact on your ability to give us some opinion as to how the little balls that you saw got to be on the inner side of the sock that you saw on April 2nd, correct?
Objection.
objections to the formal question.
Overruled.
Freezing and thawing, I do not conceive as a mechanism that would allow the things that I observed in the cutout portion on the opposite side to have been formed. I can't imagine a mechanism by simply freezing and thawing unless you purposely put it in a high humidity cabinet that could cause that. I just don't see that that's a factor.
So it's your opinion then, sir, that even though you're not aware of how many times it was frozen and unfrozen, you're willing to give the opinion to this jury that that would have no impact on whether or not those little balls would appear on the other side of the sock. Is that correct?
Overruled.
The statement I made did not say have no effect. I said that might explain an effect, but I cannot imagine how simply freezing and thawing, or the number of times it's done, would have any significant effect upon creating what I observed when I looked at them on April 2nd.
But you don't know, do you, sir?
Of course not.
And you cannot tell this jury whether or not that's how those little balls came to be on the other side of the stain. Isn't that right, sir?
Objection, you have to answer twice.
Overruled.
I don't know what you mean by that. You'll have to explain. Is that supposed to mean a mechanism? Could you rephrase that, please?
You cannot tell us, sir, whether or not, you cannot state to this jury that the freezing and unfreezing process absolutely did not cause the appearance of those little balls on the inside of the sock that you saw on April 2nd, 1995. Isn't that true?
Objection, you have to answer twice.
Overruled.
No scientist can state absolutes. Of course not.
And you did not inquire, you examined these socks with Dr. Lee on April 2nd, isn't that right?
That is correct.
Did you discuss with him his examination of the socks on February 16th, 1995?
No.
Were you aware of his examination of the socks that he had conducted on February 16th, 1995?
To the extent that he just observed them, I do not believe he made a microscopic examination at that time. That is my best recollection.
But you do not know.
I don't recall further, so I don't know.
And you do not know whether he, in the process of his examination on February 16th, 1995, twisted and pulled the socks in an effort to get a better look at any side of it or any aspect of it, do you?
Objection, assuming facts
Sustained.
on evidence.
Sustained.
Are you aware, sir, of the fact that LAPD set up a microscope for Dr. Lee to use in his February 16th examination?
No, I was not aware of that.
And in the course of a microscopic examination, sir, in your experience, can it occur that material or fabric will be pulled or twisted in an effort to get a certain area under the field of view?
Certainly.
And would it be important to know whether that had occurred on multiple occasions with this particular sock?
It could be, but I can't imagine exactly how.
But it could add important information, sir, with respect to determining how those little microbes got onto the side of the sock where you observed them in 1995.
Sustain. Raise the question.
I'm sorry. Little balls.
They're not microbes. Microbes are alive. Now I forgot the question.
Could it be important information whether or not the sock was repeatedly manipulated and twisted during repeated microscopic examinations to determine how those little balls got onto the side of the sock when you observed them on April 2nd, 1995?
I can't imagine how. I really don't see how manipulating the fabric could create dried balls of red fluid inside of a sock. It may be possible, but I have no idea what the mechanism would be that could cause those to form simply by manipulation. They were dried and they were wet and they dried.
Let me ask you something, sir. You said you observed one of those little balls to be adherent to the fiber, is that correct?
Objection, that's not his testimony.
I observed several, I think half a dozen at least. We photographed the one that showed the bonding to the fiber the most distinctly.
Okay. Is it, sir, based on your examination, one was bonded well enough to photograph, is that correct?
Objection, that's not his testimony.
I think they were all bonded, but this one showed the bonding to a fiber that was also part of the woven thread. That's the reason it was selected.
And that's the reason you took only one photograph, although you saw 6 or 7 of those little balls. Is that right?
Now, I didn't take the photographs. Dr. Lee actually clicked them off. I observed them.
You observed them, but there was only one photograph taken. Is that right, sir?
It's the only one that I have seen. I think it's the best representation, and I'm sure that's why he enlarged it.
Is your answer yes?
What was the question? Did I observe just one?
No. No. Mr. McDonald, please listen to the question. I asked you whether there was only one photograph taken of those little balls that you saw on the inner surface of the sock.
I answered that when I said Dr. Lee took it. I did not take any,
The question is only one photograph, correct?
to the best of my knowledge.
And that one photograph was taken because, in your opinion, or in your collective opinion, that demonstrated most clearly the bonding of that little ball. Is that correct?
That is correct.
Now, let me ask you something. With respect to that little ball that you saw bonded, what test did you perform to determine whether it was in fact adherent to the fabric or simply lying in the weave where you saw it?
It seems to surround the fiber or the thread-like material to which it is bonded, and it didn't move, so it didn't fall off. We're dealing with something extremely small. We didn't do any testing. To try to abrade it would perhaps fracture it, but it's exceedingly small. We did no actual testing except observation.
All right. As a matter of fact, those little balls that you saw, you said 6 or 7 of them?
Yes.
Did you make any effort to quantify those little balls?
As to volume?
Yes, as to volume, sir.
No.
If you took those 6 or 7 little balls and put them all in a purple top tube and stacked them on top of each other, could you see them?
Not without a microscope, or unless you're extremely myopic.
And yet the stain on the outside of the opposite side of the sock, you said was 50 microliters, 60 maybe?
Yes.
And all you had was those 6 or 7 little balls that you couldn't even see if stacked up together with the naked eye. Is that right?
Or grouped, yes.
Now, with respect to the manipulation of the sock, sir, you indicated that strike that. These socks, they were stretchy, elastic in nature, were they not?
Yes.
Blood, when it dries, is not elastic, is it, sir?
No.
Now, if you were to have blood dried on a sock, and then you were to stretch it, blood might flake off, if even in only microscopic amounts. Would that be true, sir?
Yes, it is.
And if the sock is stretched in some fashion, which causes the bud to flake, and then the sock is compressed through storage in a bag. There will be some microscopic or some flaking happening of the blood that has dried on the sock. Isn't that correct?
That's correct. There should be.
And if, in fact, the blood that has hit the outer surface of the sock has seeped through to the inside, if it rubs against the other side in a dried condition, causing by friction, there will be some flaking as well, will there not, even if only microscopic in amount?
Well, it's even simpler than that. It wouldn't have to flake off and go through the sock because when it dries, it's through the sock to begin with. So it could flake off from the inside of the outside surface at that point. And then if it landed on the inside, you would have some flakes on the side opposite the inside. Yes, that could happen.
And you indicated that you were not present when Dr. Lee did his examination of the socks on February 16th, 1995. Is that right, sir?
That is correct.
Now, on the date that you did the examination with him, did you turn the socks inside out?
I think we did after the initial photographs were taken.
And when you say the initial photographs were taken, are you talking about the photographs of the little balls?
Yes, I believe we took all the photographs before we did any what you could call stretching or manipulation of the socks. We left them quite flat as we took them out.
Do you know whether anyone turned those socks inside out or twisted them in any fashion before you made that examination on April 2nd, 1995?
No, I don't.
Would that be information that you would like to have, sir, informing your opinion as to how those little balls got onto that side of the sock?
No.
You don't think that would be important to know?
No, not unless you added many factors, such as if the socks were wet and you turned them inside out. That might make a difference, but you're exposing the inside where I detected these small balls of red material to the outside at that point, so you're defeating the purpose of transfer. Mm-hmm. That would no longer be in contact with the area that was stained, so you're losing ground that way if you're trying to transfer them.
No, let me ask you this, sir. You don't know whether they were wet on some occasion after the blood was detected on August 4th with that Q-tip, correct?
No,
No foundation for that.
Sustained. Phrase the question.
Well, Your Honor, I have a series of 3 photographs I'd like to show to the witness. I'll show them to counsel. Be marked Peoples 554,
554.
555, and 556.
Yes, 554 is the first number.
All right, so I'm going to show you a photograph. You recognize the... Can you recognize the person in that photograph, sir?
Yes, I do.
Who's that?
That's Dr. Henry Chung Lee.
All right. Did you see him perform the manipulation with the sock that he is in this photograph in your presence on April 2nd?
No, I did not.
Did anyone... Were you ever...
I'm sorry, can we have a sidebar?
Let me see the photographs with clipboard, please.
These photographs, we will stipulate, were taken on February 16th, 1995.
All right, is that agreeable to the defense?
Yes, on the date when Professor McDonald wasn't there.
That's correct. Thank you.
Okay.
So you did not see this manipulation by Dr. Lee, correct?
I wasn't there. No, I did not see them.
And he didn't do that kind of manipulation again in your presence on April 2nd, is that right?
If he did, I didn't see him do it. I don't believe he did.
I'm showing you now People's 555. Again, you recognize Dr. Henry Lee?
Yes, I do.
This is his manipulation of the sock on February 16th, 1995 again.
Now, that appears more of a manipulation than the first one. The first one, I'd say, just holding it up, not manipulating it. This one, it appears he is either turning it inside out or at least manipulating it in some fashion.
And is that something that you also did on April 2nd, 1995?
We turned them inside out, yes.
In the manner in which Dr. Lee is doing?
In any manner you can to turn socks inside out, I don't think there's much choice. This looks about the only way to do it.
All right, now I'm showing you People's 556. Appear to be a photograph of Dr. Lee taking a picture through a microscope, sir?
Yes, he's taking a picture through a stereobinocular microscope using the right ocular.
And again, we stipulate this is February 16th, 1995. Is that right?
I don't know.
No, I'm asking counsel.
I'm sorry.
Okay. So it would appear that he did examine the socks under a microscope on that date, correct, sir?
Yes, a low-power stereobinocular. I think the maximum magnification is about 25 diameters with most stereobinocular microscopes.
Okay. Now, the microscope that you used on April the 2nd, 1995, had what power magnification?
It was 7 to 70.
You do not know, or do you know for a fact, have you ever seen this microscope up closer?
Not this particular one, no. I have one, but not exactly the same model.
So are you sure when you say that this the greatest magnification power on this microscope would be 25 times?
No, that's why I said they're usually 7 to 25.
Now, the photograph that you've shown us here, of the little ball on the inside of the sock, that was taken on April 2nd when you were present, correct?
That's correct.
You don't know of any such photographs that were taken on February 16th by Dr. Lee, do you?
No, I...
No foundation for that question. Didn't even know that he was there.
Sustained.
Have you been shown any photographs taken by Dr. Lee on February 16th showing the little balls on the inside of the sock?
No, I have not.
And the photograph that you've produced here in court showing the little ball on the inside of the sock, the one that you have shown, is what magnification?
I would approximate the magnification of the actual print to well over 100 diameters, but I have not made that calculation. I do not know the diameter of the first picture that I saw, which is a 4x6, and if I don't know how big the magnification is on this, I could ordinarily make the correction, but without knowing a starting point, I can't proportion it up. I'm estimating from memory of what I saw that would be about 100 or more diameters. Dr. Lee could tell you exactly.
All right, Ms. Clark, our record is rather sloppy here. You're referring to photographs of red balls. Which exhibit are we talking about here?
And I can't remember their defense
I think
exhibit.
it's 1278. I think, I'm not certain.
1278?
Yes.
Because one is with
You're
just
referring it to a counsel, so you tell us which one you're talking about.
I'm going to...
That's 1278.
That one.
Is that large one, 1278, Mr. Gordon?
Yes, Jim.
1278.
Is that 1278? Okay, this is the one we're referring to, sir, is the one with the little ball in the blue circle?
Yes,
That's 1278.
correct.
Okay. You were not shown any such photographs that were taken by Dr. Lee on February 16th, 1995, correct?
That's correct.
To your knowledge, do any exist?
Objection.
Sustained. He hasn't seen any.
All right, sir. Now, were you aware that on August 4th, the same day the socks were tested, given the presumptive test for blood, the first step of which you saw, the sampling of which you saw in the photograph, Susan Brockbank also examined those socks for hair and trace. Were you made aware of that?
I believe I read that, yes.
And that has no impact on your opinion as to how those little balls got there?
No, it does not.
And you were also made aware then that Greg Matheson performed serological testing for PGM subtyping on that sock after August the 4th. Were you made aware of that, sir?
Objection, it's misleading for your approach.
Oh, we'll rephrase the question, though.
Greg Matheson performed PGM subtyping on that stained area of the sock after August 4th. Were you made aware of that?
Objection, because he cuts out a portion and removes it.
Yes. Rephrase the question.
Were you made aware of the fact, sir, that that to perform PGM subtyping testing, Greg Matheson cut a portion out of the sock in order to perform that testing?
Yes,
And that he had to handle the sock in the process of doing that?
obviously.
And that has no impact on your opinion as to how those little balls got there?
No, it doesn't.
Now, you prepared a report in this case, did you not?
Yes, I did.
And that report is dated July 11th, 1995?
I believe it is.
You've been working for the defense since August of 94, is that right?
Well, that's when they first contacted me. I actually didn't have anything to do until I had made a trip to Albany, I think in December.
And this report is the only one that you have prepared in this case, correct?
That's correct.
And it details only your observation of the one area of the sock where you saw those little balls, correct?
That's correct.
You examined both socks, didn't you?
Yes, I did.
And there's nothing in your report about the other sock, is that right?
No, there isn't.
Or any of the other stains on the sock that you did observe?
That's correct.
So it's just your report is confined to the one stain that you've testified to here in court, is that right?
That's correct.
Now, if I understand your testimony correctly, sir, the inside of that stain, I'm going to try and number these surfaces, make it easier. The outside portion of the stain where the blood was first received is surface 1. Inside, surface 2. The inside of the opposite side, surface 3. Okay? It's your testimony, sir, that the transfer to surface 3 came from surface 2. Is that right?
Yes, if it's transferred from that surface. Again, I did not determine what that material is. The only way it could have gotten there is for a liquid that is red to have gone from surface 2 to surface 3.
And now you've testified that you did not perform any test on the cutout area, on that cutout fabric from the center of the stain to quantify how much blood was in it.
That's correct.
Now, if the, as a matter of common sense, would it be fair to state, sir, that the more blood you have on the inner aspect of that stain, the more little balls you expect to find on the opposite side?
It's vague as to inner aspect.
Sustained. You just finished numbering the sides. Won't you?
All right. The more blood you, or the more liquid or blood that you have on the area of surface 2, the inside of the sock, the more little balls you're going to expect to see on surface 3. Is that right?
As you said, it would be more likely. It's common sense, certainly.
And of course, this assumes that the little balls on surface 3 can be attributed to the stain on surface 2, correct?
Absolutely.
And you have not said that you make that assumption, have you not, sir?
cannot say that you
No,
haven't said
I-
it, have you not?
See?
All right.
Clear to me. You indicated that, I believe in your direct testimony, you made the statement that if the stain in surface 2 is related to the little balls on surface 3, that they would have gotten there when wet. Do you recall that?
Yes.
But you cannot say that the little balls on surface 3 are related to the stain on surface 2, can you, sir?
No, I can't.
Now, it would be true, would it not, that the more blood you have on surface 2, the more little balls you expect to find on surface 3,
Only if the little balls are blood.
if they are?
Yes, certainly.
And you found only 6 or 7, is that right?
That's the number of what I would call balls, which looked like a wet material that dried, adhering to fibers, yes. I saw other red spots.
Let's just talk about those little balls for a second. You only brought in a photograph of one of them, correct?
I think
I-
we've asked this question now 3 times, Counsel.
Why weren't all of them photographed, sir?
I have no idea. We photographed the most representative. Dr. Lee, again, took the pictures, and that's a question you'd have to direct to him. I observed them.
Now, you made no attempt to quantify the volume of those 6 or 7 little balls, did you?
We've asked that question.
Okay. You indicated that there were also other little flakes.
There are many red spots that show up in the photograph that has been introduced that are clearly little red areas. And if the microscope was adjusted in its depth of field, in other words, focused, you would lose the one that we have photographed, and then you would see others. So they're clearly evident. There are red areas in there, and those are the areas to which I made reference.
But they are not photographed, are they, sir?
Yes, but they're out of focus.
So you can't see them in the photograph that you took.
You can see them, but you can't resolve them.
So did you make any attempt to have a photograph taken that would resolve them so the jury could see them?
Sustain, rephrase the question.
Did you make any effort to take a photograph that would have them, those flakes that you saw, in good resolution?
Oral.
The photograph that's introduced shows the best representation of the drying of a red fluid. Other red spots could be flakes, as you just stated. They could have been other of the red balls we saw. I cannot tell because they're so far out of focus. They are not resolved.
Though these little balls are a very important aspect of your testimony, are they not, sir?
Sustain.
All right, sir, in your terminology, a swipe is different than a compression, is that right?
To the extent that one involves lateral motion, the other involves compression, they are both transfer mechanisms.
They are both methods of transfer, is that what you said?
I said they're both transfer mechanisms.
Nevertheless, are they separate and distinct mechanisms of transfer?
Yes, as opposed to other means of staining, such as dripping or projection.
Well, you took great pains to explain to this jury, did you not, that this was a compression and not a swipe. Is that right?
Sustain, rephrase the question.
You went into some length in your testimony, sir, to describe for this jury how this was a compression and not a swipe.
Sustain, sustain, rephrase the question.
Sir, were you attempting to explain to this jury the difference between a swipe and a compression with regard to your observation of the stain on this sock?
I thought I did it. I didn't attempt. I thought I explained it clearly enough, the difference. Yes.
And why did you want to explain to them the difference between a swipe and a compression?
So they would know they're both surface. I think I was asked if it was a swipe initially, or that came up, so I differentiated between the two. I said I looked to see if there were any trailings or featherings to see if it was a swipe. The difference between the two is really not significant. It's just a matter of my classification.
If it's not significant, sir, then why did you draw a distinction before the jury?
Because there is a distinction.
Then some transfers are swipe and others are a compression. Is that right, sir?
That is correct.
And they are distinct in your opinion.
They're different. One involves lateral motion, the other does not. That's the extent of the difference.
Okay. So a swipe could occur if I move my ankle across a wet surface, is that right?
Objections to vague as to wet surface.
Sustained.
A swipe could occur if I move my ankle against a wet wound.
Certainly.
Now, your report, sir, is an accurate summary of your findings with respect to the sock A, is it not?
I believe so, yes.
And you took pains to make sure that it accurately reflected your findings in this case, did you not?
Objection as to Haynes.
I prepared it as accurately as I could at the time. I have no reason to suspect there's any error.
And you signed the report, did you not?
Yes,
And you reviewed the report before signing it, I take it?
I usually do.
And you examined that report before you testified, did you not?
Not recently. I did it, I think, 2 trips ago.
You prepared that report, sir, based on your observations of April the 2nd, 1995, is that right?
That's correct.
And in that report, you documented what your observations were.
To some extent, yes.
But it was an accurate summary, was it not?
I believe it to be.
Do you have a copy of your report here, sir?
Yes, I do.
Would you mind getting it out, please? Thank you. Sir, let me direct your attention to paragraph 4. Did you not write in this report, sir, when this sock is laid flat, the stain described in point 2 is directly below the stained area described in point 1. The only reasonable conclusion, therefore, is that the fluid that caused these stains was swiped against the outside of the left side of the sock. That is what you wrote in your report, is it not?
That's correct.
And you consider that to be an accurate depiction of what you observed on April the 2nd, 1995. Is that correct?
That's what I wrote, yes.
That's what you wrote. And yet you testified to the fact that you now believe that to be a compression and not a swipe. Wasn't that your testimony, sir?
That was my testimony.
Now, sir, wouldn't you agree that with respect to the differentiation that you have made, the distinctions that you have indicated you made between swipe and compression, that was an important distinction, was it not?
It's not important at all, as I said. Swiping shows there is a lateral component to a compression. They're both transfer mechanisms. Compression occurs in swiping. And I wrote swiping here. It would not matter whether it said compression or swiping. This pushing of blood or any fluid into a fabric is a compression.
And yet,
swiping merely means there's lateral movement accompanying it. When I looked at it here, it appeared to be swiping. I have since seen enlarged photographs that we took that show that the swiping appearance, which is on the surface of the fibers, seems to be fairly uniform on both sides. So now I would say it's more likely a compression only. Both are compression. One has lateral movement. I described lateral movement as well.
all right, did you take any notes at the time that you made your observations of this sock to document what you saw?
Yes, very, very few. Dr. Lee was described.
Did you personally took notes, sir?
Yes, Very.
Did you turn them over to the defense?
Yes.
They can turn it over to the prosecution.
No, they have not.
All right, we'll take this up later. Proceed.
May I see those notes, sir? Thank you.
You're welcome.
Tell me where in those notes, sir, you indicate that there was no lateral movement in the stain that you characterized in your report as a swipe.
I don't characterize it either way.
And tell me where in your report you demonstrate or you document your observation that there was no lateral movement.
I don't believe I did.
And tell us where in your report you document the observation of voids that you've testified to here in court.
I don't believe I did that either.
Now, the lack of lateral movement and the appearance of voids were the indicia that you testified to as evidence that this was a compression and not a swipe. Isn't that your testimony?
That's correct. And when I indicate voids for descriptive purposes, that's one thing, but I don't have to indicate them to know what I'm seeing. So I know what the meaning of the term is. And that's why I wouldn't bother to put there are voids here, there are voids there. That is part of seeing a compression transfer or a lateral transfer.
But you did not put down compression transfer in your report, did you, sir?
No, it was written for attorneys, not scientists.
Sir, you are aware of the fact that counsel has retained you as an expert, isn't that right?
I hope so.
And you are aware of the fact that the report that you give to them is turned over to the people as well before you testify.
Certainly it is.
You filed no addendum to your report to reflect the change from swipe to compression, did you?
There's no change. They're both transfers.
They are both transfers, but you made a distinction. You made a point of telling us it was a compression and not a swipe. Isn't that right?
That is the way it appeared at the examination. The photographs I examined later showed it to be more uniform, and therefore I concluded it was more likely simply a compression. It could still be a swipe.
And you filed no addendum to indicate to the people that you were going to change from the swipe that you indicated in your report to a compression that you testified to here in court. Isn't that right?
Sustained. Rephrase the question.
What effort did you make, sir, to inform the people of the fact that you weren't sure if it was a swipe or a compression, but you were leaning towards compression?
Objection of relevance to what you notified the people.
Sustained.
Sir, knowing that your report said a swipe and said nothing about a compression, wouldn't you agree it was very misleading not to make an effort to inform?
Sustained. Argumentative counsel.
You did not write any new report to indicate that you were uncertain as to whether it was a swipe or that you had changed your mind, to say now that it was a compression.
From July 11th, I haven't had time to read my initial report. I've been traveling. I have not made any addendum, no. There's no correction to be made.
No correction to be made because it could still be a swipe. Is that your testimony?
It's a matter of interpretation. If you agree that the fine blood on the surface of the fibers is uniform on each side of that elliptical stain, then it's more likely compression. It's a compression mechanism if it's a swipe. It could be that the leading edge and the trailing edge are basically the same geometry. It's a distinction that is really, in my mind, totally irrelevant.
So to you it makes no difference whether you call it a swipe or a compression. Is that your testimony, sir?
A swipe is a compression with lateral motion.
Do you recall how many times in your testimony on direct examination you said that this was a compression and not a swipe?
I may have said it several times. I have no idea how many.
And if that is the case, sir, that you said it several times, what would be the point of that if it were unimportant to distinguish between the two?
Sustained.
If it makes no difference, sir, then why testify before this jury repeatedly that it was a compression and not a swipe, if it doesn't matter?
Well,
So they would be reminded and understand it.
But you didn't make any effort to tell this jury that it didn't matter whether you call it a swipe or a compression until just now. Isn't that right, sir?
Sustained.
You did not tell the jury before cross-examination that it didn't matter whether it was a swipe or a compression, did you, sir?
No, I did not.
Oh,
Now, is it... Now, the notes that you have before you that were made contemporaneously with the observations on April the 2nd contain no description of little balls, do they?
No, again, I was not the scribe. I made a couple of very simple sketches, and Dr. Lee made all the tests and made all the detailed notes.
And can you tell us, sir, if you have his notes with you?
I believe I do have his notes.
Please look at his notes and tell us whether Dr. Lee has any description in his notes of little balls, lateral swipe, or voids.
No, he only mentioned that he took photographs of them.
He mentions that there are photographs taken of the holes. Isn't that right, sir?
Photographs taken, and he indicates little tiny dots within the cutout area. He states blood-like materials were observed on the inner surface of the other side of this cut, and he's got many little tiny dots, and it says photographs taken, photomicrographs.
And where is the description in his notes of lateral swipe, excuse me?
He doesn't use those words. He says a reddish-brown color he shows it around the cutout area.
Mm-hmm. There is no note there concerning lateral swipe, isn't that right?
Not on this page, no.
Nor on any page of his notes,
none
is
that
there?
I recall.
Right. And there's no mention in there of voids either, is there?
There was mention of voids and lateral transfer, but not in his report. We discussed it.
There was verbal discussion on April the 2nd. Is that what you're saying, sir?
There was.
But there is no written record to document that. Isn't that right?
Not that I'm aware of.
And the only written record that you made concerning your observations of the socks with respect to the nature of the stain and the little balls is the report dated July 11th. Isn't that right?
That's correct.
So between April the 2nd and July 11th, you made the observations on April the 2nd, but you wrote nothing down concerning your observation of the little balls, the voids, the lateral swipe, until July 11th. Is that right?
That's correct. I wasn't in the country.
So you wrote that report from memory. Is that right?
Yes. And the very, very few lines that I wrote in my description, which are in your possession.
I'm sorry?
The few notes that I made are in your possession. I referred to them.
No, I gave them back to you, didn't I?
Oh, you did? Oh, I'm sorry. Yes, you did. Thank you.
But these notes do not contain, excuse me, sir, a description of evidence, do they?
No, just a sketch.
As a matter of fact, those notes just document your receipt of the evidence and the date and time and what you got. Isn't that right?
Well, it lists the time that was spent examining the two items, 42A and B, according to my notes, and the length of time.
Now, your examination on April the 2nd was done with a very high-intensity light. Is that right?
Yes, high intensity.
And a microscope. Is that right?
Correct.
And you will agree, will you not, that the observation of blood on those socks was a difficult one in view of the dark color of the fabric, sir?
Not when you've got good high-intensity illumination. It would be difficult in this room, yes, but under the conditions that you would use for an examination, it was not difficult. It was straightforward.
And again, though, when you're talking about high-intensity light, can you explain to the jury what you mean by that?
High intensity is more lumens per square centimeter. A pocket light like this can give extremely high intensity right at the end, much more than a 1,000-watt bulb would give here on the ceiling, if the bulb was on the ceiling. So high intensity is the concentration of light in a given area, and it's expressed physically as lumens per square centimeter.
So it would be, if we were to light up this courtroom with that kind of high-intensity light, would we all be wearing sunglasses?
We ought to be. I would be if I could, or I'd close my eyes.
Now, with respect to the distinction between swipe and compression, sir, you did indicate that you observed crime scene photographs, correct?
Yes, I did.
Can I approach?
Thank you, better. All right, Ms. Clark, you may conclude.
Sir, now in characterizing the stain on the outside as a swipe and then changing your testimony in court here to a compression, were you
Sustained. Rephrase the question.
you initially characterized the stain as a swipe, is that correct in your report?
In the report, yes.
And then you came in and you testified to say that it was a compression and not a swipe, is that correct?
No, it could be a swipe if the leading and trailing edges are uniform, as they appear to be in the large photographs that I found that Dr. Lee had taken.
So you're saying it could be either one at this point?
Yes, they're the same thing. They're both compression transfers. One has a little more lateral motion than the other.
One has a little more pressure than the other, doesn't it, sir?
Not necessarily, no. You have to have pressure or you won't get any transfer at all.
All right, so compression then could be from touching,
Yes, that's compression.
could be from pressing,
Touching is pressing.
okay? So you don't, what you're saying, sir, is that there's no particular amount of pressure implied. Any pressure will indicate compression, is that right?
There has to be sufficient pressure to transfer a liquid to the surface, and that's very minimal when you have a liquid.
In characterizing it as a compression instead of a swipe, in your direct examination testimony, were you attempting to be more helpful to the defendant?
Sustained. Argumentative.
Well, in characterizing the stain as a compression as opposed to a swipe, were you attempting to make it sound more sinister, Mr. McDonald?
Overruled.
I am a scientist, not an advocate, and I am not changing, modifying, or correcting anything for anyone's benefit except to clarify the matter to the jury. That's my purpose here.
Nevertheless, would you answer the question, sir? Do you think, in your mind, that saying it is a compression makes it sound more sinister than a swipe?
Sustained. Sustained.
You saw photographs of the crime scene, have you not?
Yes, I have.
And let me ask you this, sir. If someone wearing the socks that you saw were to step near to the body of the victim, Nicole Brown Simpson, near enough for the ankle bone to come in contact with her bloody hand, could that cause a compression transfer?
Certainly.
Could it also cause a swipe?
Yes.
If she were to reach a bloody hand out and touch her thumb or finger or hand to the ankle of Mr. Simpson wearing those socks, could that cause a compression or a swipe?
Rephrase the question. Rephrase the question.
If Nicole Brown Simpson reached out a bloody hand to touch the ankle of the murderer wearing those socks, could that cause a compression or a swipe transfer?
Objection, no foundation.
Overruled.
Certainly it could. Anything that has blood on it can either be projected and touch the area that's stained, or this area that's stained could have come in contact with it. It's simple transfer.
Well, for example, I see the way you're sitting, sir. I can't demonstrate this, obviously. But if you were to, can the jury see the way? If you were to move your knee back, sir,
My knee, all this.
yeah, to where your ankle bone, the bony protrusion of your ankle, was on top of your knee, could that produce a compression or a swipe?
If one surface was wet, yes.
Now, you noted, sir, that the stain appeared to be in the area of the ankle where there would be the bony protrusion of the ankle, correct?
It appeared to be in that general area. I don't know if the socks were put on, if it would be at the outermost portion or the apex of that circular area, but in that general area, yes. It very well could be at the extreme of the ankle bone.
Okay. And by the extreme, you mean the highest point, the point that protrudes the most?
Correct. On
Now-
either side of the leg. There's one on each side.
Right. And by the way, sir, by looking at the sock, could you tell whether it was a right or left sock, sock A that we're talking about here?
No.
Okay. By the way, and did you happen to ever look at a photograph of the socks in the condition in which they were found on the bedroom floor?
I've seen some pictures of it, yes.
This has been marked so many times, I hate to mark it again, but it's People's 127 already marked. I have one handy, if I may.
127.
Let me ask you, sir, if you've seen this photograph before.
Yes, I have, or one just like it.
Now, you've seen the socks in person, correct?
Yes, I have.
And do they appear to be inside out in this photograph, sir?
Like a magnifying glass?
Yeah.
I've got one, but I don't need it. I honestly can't tell. If I had the socks to compare to this, I might be able to, but I don't think so. It's just heavier fabric in the heel and the toe. The upper portion seems to be inside out, but to tell whether the whole sock is inside out or not that's lying down, I honestly can't tell you.
Nevertheless, they are lying flat on the, somewhat crumpled, but lying on the floor, correct?
One is more or less folded over. I don't know which side is up or down. It would appear that it is the left side of the one that is spread out the most that is down, but the other one is kind of wadded up.
Okay. And so the jury knows what we're referring to. I'm going to put it on the monitor. I wanted you to see it, sir, because I don't know if your monitor is going to give you as much resolution as you get looking at it up close. Now, when you said that one appeared to be more crumpled up, you were referring to the one up on top, were you not, sir?
Yes, I was.
All right. And now let me ask you a question. If you have, maybe it's just a matter of common sense, but if you have a bony protruding area on an item of clothing, like around the ankle bone, you're wearing a sock, that area is sticking out, that area would be more likely to get blood, assuming blood is in the area of the feet. Would that be a fair statement?
Yes, if it was transferred, but spattering or something would be not dependent upon that. But brushing against something, yes, the bone sticks out further.
Right. So the bone area where you found that blood stain would be the place that would be most likely to receive blood from a transfer if you're in the area of blood or a bloody body, correct?
Yes, if that transfer, again, is in right on the ankle bone. I think it would make a difference whether you had it on the right or left foot, though. I think there's a slight difference, but I don't know. It's in that area. I don't know that it's at the peak of the bone, as I said. Of course, the sock is elastic, so you could adjust it so it was or it was not.
It was not. But it was in that general area, you would agree, sir?
Yes, I would.
So if that sock was worn in the commission of a murder and the feet were in the area of a bloody victim, an area that would swipe the bloody victim, then the area where you found the stain is the area most likely to receive that swipe or compression, correct?
Oh,
I would say yes.
Now, let me ask you a couple other questions, sir. As a matter of practicality, if someone is sweating and they are wearing socks of this kind of nylon nature, as a practical matter, is it not more difficult to take socks off of a sweaty foot?
sustain.
Have you ever had... Well, I don't know. Mr. McDonald, have you ever had the experience of wearing nylon socks and exerting yourself to the point where you were sweating?
I used to wear work socks in the oil fields where I grew up and did a lot of manual labor, but I do not honestly remember ever sweating to the point where my socks got wet, and I didn't wear dress socks in the oil fields. I don't sweat when I wear dress socks, and if I can avoid it, I never wear them.
Okay. So you've never had the experience yourself, sir, of sweating in dress socks?
Not that I can remember, no.
Well, can I ask you, sir, if in your experience you have ever had occasion to note whether wet socks or sweaty feet make thin socks like this more difficult to remove? Do you have any experience in that? So I'm trying
She's
to
asking for the foundation at this point. Do you wear these kind of socks?
No.
Men have very particular preferences about their socks. Next question.
All right, if someone has bloody hands, sir, and they attempt to take a sock off by maybe inserting the thumbs inside and the fingers on the outside, if one or more of the fingers are bloody and pressing into the sock, will that cause a compression?
Oral.
Well, certainly, if you have bloody hands and you touch any fabric, you can transfer blood to it.
Okay. And if you were to touch, if there were wet blood on a piece of fabric that you pressed, that would cause a compression as well, correct?
If the blood was already on the fabric,
Right. And it was wet.
you would squash the blood out of the fabric a little, laterally, yes. It wouldn't cause a transfer unless it was in contact with something else. If you're transferring it to the thumb, yeah, you could transfer it from the fabric to the thumb, if that's what you mean.
What I'm saying, though, sir, is that if there's wet blood on a surface and you press it, will you cause a compression?
If you press it, you cause a compression, yes.
And if wet blood is on a surface and you brush it, will that cause it to appear as a swipe?
Yes, it will. At that point, we would call it a swipe pattern produced by a wiping action.
And can you tell the difference, sir, between whether or not a blood drop has been dripped and swiped later? You know what I mean? Let me make that more clear. Can you tell the difference between whether or not a drop of blood is dripped onto a surface and while still wet, swiped between a blood that is initially swiped on?
If there's enough blood to remain on the surface that doesn't quickly soak right into the fiber of the fabric, you could laterally transfer it and cause a swipe pattern, yes.
In which case, what you would detect would be a swipe pattern as opposed to a drip and a swipe.
I thought I was just answering the drip and swipe. If you dripped it, first of all, you're talking about just a drop of blood on a fabric.
Mm-hmm.
If it falls on the fabric and you very quickly create a lateral motion, you should get a swiping of that blood, which will leave blood on the top of the fibers, yes.
And then when you come to analyze it, you would see a swipe and not a drip and a swipe. That was my question.
Yes, that's correct.
Okay.
You couldn't tell the difference if it was done quickly. That's
Okay.
correct.
And the same would be true, I take it, for a compression. Is that right?
Yes, if the blood is still fluid enough, you can get a lateral motion, and it would look like a swipe.
And likewise, sir, if it was with respect to a stain that you called a compression, if the blood was still fluid and then compressed with a hand or a finger, it would look like a compression to you, would it not?
Well, you just said if it was a compression, so it would look like a compression, yes.
As opposed to a drip and then a subsequent compression.
I think that would be a very difficult thing to differentiate with any degree of accuracy.
Now all right, those little balls on the surface 3, you do not know, those were not typed to determine whether they were blood, correct?
As far as I know, they never have been.
And you don't know, obviously, then,
Objection, Your Honor, that's for sidebar.
assuming they are blood, sir, you don't know whose blood they are, is that correct?
That is correct.
Now, you indicated that you determined, without ever having seen the actual piece of fabric cut out of the center of the stain, you gave us an estimate that the entire stain would have been 50 to 60 microliters of blood, assuming it was blood.
That's correct.
Okay. And that what you saw on the opposite side in terms of the little flakes and the little balls, you never attempted to quantify, is that right?
Other than to say there was an extremely small volume, no.
It's asked 3 times.
Actually, this is the 4th time. You're right.
All right, so let me ask you a few questions about your background. Do we have to quit exactly at 4?
Yes, we do. We have a doctor's appointment that we have to keep.
Oh, that's right, that's right, that's right. All right, would you like to break now then, Your Honor? And I have one very short area that I intend to complete tomorrow. I won't be able to complete it before 4 o'clock.
Well, why don't you finish what you can?
Okay. All right, sir, you stated that you were a professor of chemistry at Milton College in Wisconsin for a period of time?
Yes, I was.
Yeah, is that college now closed, sir?
Yes, it is.
When it was open, it was a small liberal arts college, is that right?
That's correct.
About, what, 350, 500 students?
Oh, I don't think they ever had 500 while I was there. More like 250 to 300, I would think.
Now, let me ask you, at the time that you became a professor, you had an undergraduate degree, correct?
That's correct.
And you became the head of the Department of Chemistry at Milton College, is that right?
That's correct.
Now, when you were head of the department, sir, the entire chemistry department consisted of who?
Me. I was it. I replaced 2 people and offered 12 courses.
Okay. Did you give yourself assignments?
I gave a lot of assignments.
I mean, as head of the department. That was a joke. All right. Did you taught criminalistics at Elmira College in New York?
Yes, I did.
And you left there in 1983, is that right?
That's correct.
Okay. You said adjunct, but that's a part-time professor, is that right?
Part-time rank of full professor. I believe they have adjunct, associate, adjunct, assistant. It varies from one school to another.
Okay. So what were you teaching at night, sir?
Yes, I was.
Was that a continuing education course you were teaching?
Continuing education courses. I taught quite a few.
Was that 2 to 3 days a week?
It depended. It was usually 2 nights a week, and 2 nights a week every semester, and the summer.
You taught one time at Corning College, is that right?
For quite some time, Corning Community College.
Okay, that's a 2-year college, is that right, sir?
That's correct.
So they don't give any degrees other than AA?
I'm not sure about that. I think they have, since I left, negotiated some form of getting a 4-year degree or a master's program through John Jay College in New York. I'm not sure about that, but basically it's a 2-year school, part of the State University of New York.
Okay, and again, there you were teaching part-time?
Yes.
And was it night school again, continuing education program?
It was days in the beginning in 1960, and then it went through different transitions and ultimately ended up in the evening program, yes.
And was that, again, 2 to 3 nights a week?
It varied depending on the semester, but 2 nights a week was the most I could do.
Now, with respect to either Elmira College or Corning, sir, would you say that either one of them had a formal forensic science program?
They did at the time. They had a criminal justice program at both places. Department of Criminal Justice, I think, was what they called it. They also had a forensic science certificate.
Okay. But when I say a formal forensic science program, sir, I'm talking about something akin to formal program for the giving of a degree in criminalistics or forensic science.
They gave a degree with a major in criminal justice. I don't remember the exact title of it. That's what it was.
Okay. The criminal justice program, sir, is like the administration of justice, isn't it?
Well, that's part of it, I guess, yes.
It is not primarily a science program, is it?
No, but it satisfies certain science requirements, or at least it did.
It's primarily a coursework, a study of coursework that deals with the criminal justice system, isn't that right?
In general, but my work was primarily in the forensic area of physical evidence and crime scene investigation and microscopy and so on.
Here, sir.
Yep. All right, ladies and gentlemen, we're going to take our recess for the afternoon session. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. Take care of yourselves. Stay well. Is there anything we can do in that respect to help you out? Let us know. All right? Get plenty of exercise, fresh air. See the doctor when you need to see the doctor. All right, as far as the jury is concerned, we'll stand in recess until 9 o'clock. After we clear the courtroom, we'll get Mr. Bosco's status report. And Professor, we'll see you tomorrow morning, 9 o'clock. The jury is not present. We needed to take up the Bosco matter.
I know, Your Honor, I'm just wondering whether or not there's two housekeeping matters with regard to the last witness that I can take up before you get into the
Sure.
Bosco matter. Thank you.
Yeah, before we do that, Your Honor, Ms. Clark has already left the courtroom.
Okay, well, summon her back.
Thank you. I'll wait until she comes back.
All right. All right, I understand we have counsel for Mr. Bosco, Ms. Osinski, and Mr. Sullivan, correct?
That's correct, Your Honor.
All right, good afternoon. Counsel, would you state and spell your names for the record, please?
Yes, Your Honor. Last name is Sullivan, S-U-L-L-I-V-A-N.
Your Honor, Helena Osinski, first name is spelled H-A-L-I-N-A, last name O-S-I-N-S-K-I.
All right, good afternoon, counsel. Thank you for making yourselves available on such short notice.
Good afternoon, Your Honor. At this time, we've just been retained, and we have not even had a chance to speak with our client, Your Honor, because he has been in the courtroom. We would like a little bit of
Take
time.
him out of the courtroom.
We would like a little bit of time, because the Shield Law is involved in this matter. We'd like a little bit of time to be able to brief it and then to have a hearing on the matter. It's at the court's disposition as to when you would like to hear this matter, but can we put it over to another day as opposed to this afternoon?
Sure. How much time do you think you need?
Well, we would like to submit something in writing by tomorrow and maybe be heard after the court session on Wednesday afternoon. Would that fit in with your schedule,
See, I
Your
think
Honor?
we have the continuation. Would you be available tomorrow at 4 or 4:15?
We could, Your Honor, yes.
That'd be fine.
Okay. All right. And Ms. Osinski, Mr. Sullivan, have you had the opportunity to confer with Mr. Shapiro regarding the issues that they seek to raise with your client?
Just very briefly, Your Honor, we've just...
All right, then
very
I'm going to
briefly.
direct counsel as soon as we break on this issue then to confer, to meet and confer and see if there's any narrowing down that we can do of the issues involved.
Thank you, Your Honor.
All right, is there anything else that we can take up as to the Bosco issue? All right, I've been provided with, counsel, do you have a copy of the article that's referred to?
Your Honor, we don't have a copy of the article or a copy of the subpoena. We have nothing.
Okay.
I gave a copy to Mr. Morrell, so I'll arrange for another copy.
Okay.
All right, I think my staff has a copy of the article in question.
Thank you, Your Honor.
All right.
Your Honor, while we're waiting for Ms. Clark, I think we have to resolve this scheduling problem now with tomorrow. I'm assuming that Professor McDonald will certainly be finished within an hour tomorrow morning. It was our intention to call, if not Tracy Savage as the next witness, certainly Michelle Kessler. However, Michelle Kessler, at least tomorrow, we'd like to resolve the 402 issue as it applies to Tracy Savage. As was pointed out to you by my colleague, Dean Ullman, we wish to add to the hopper, if you will, for your thinking about the various factors, Michelle Kessler's outside the presence of the jury testimony on that limited issue.
Okay.
There was some mention that she has an appointment, or she has, I think, a funeral or something in the afternoon. So perhaps we could do at least the outside the presence of the jury portion of her testimony earlier tomorrow. But we do not have another, and we can play the Paratus tape, but you know that doesn't take up much time. But after that, our next witness is Dr. Gerdes, and we're not ready yet with Dr. Gerdes. We'll be ready with him by Wednesday morning, but we are not ready. We were planning on having these other witnesses Monday and Tuesday.
I'm just thinking, I can't believe, although I've been wrong before, that Mr. McDonald will take up the full morning session.
No, I think you're right, he won't. Ms. Clark represented that she only has a few minutes, I believe.
All right.
Your Honor, is the court aware that Michelle Kessler is not going to be available until probably late tomorrow afternoon? She was attending a funeral.
No, I'm aware she has a funeral obligation in the afternoon. What's her status in the morning?
Well, I think she's leaving for the funeral and will not be available after 11, and then will probably be available again after 4? What's your best estimate?
Since her testimony, at least to make out this offer, should not take more than 20 minutes,
How about if we start with her at 9, do that out of the presence, and then
Right.
bring the jury down? That sounds like the best way to do it.
right.
Well, Your Honor, the other possibility would be to require counsel to make an offer of proof as to what she's going to say, or they think she's going to say outside the presence of the jury that would be relevant to the issue as to the...
I think we've already gone over that, though. If you recollect, Mr. Goldberg, this morning, we were just sort of thinking out loud that Ms. Kessler could testify to any inquiry that was made of her, any knowledge that she has, or any action that she took regarding leaks. I mean, there are things that as the then acting head of the laboratory and now the head of the laboratory that she can speak to with regards to this issue.
Well,
So I'm convinced that there's enough to at least ask her some foundational questions with regards to these issues.
What Your Honor might not be aware of is that counsel did speak to Ms. Kessler at length, so they know specifically what she would say and the extent of her knowledge on many of these issues, which is
Well,
very
that's not
limited.
the point, though, Counsel. The point is that for me to go further on the Tracy Savage issue, they want to offer more evidence with regards to the materiality of the issues concerned. And maybe I misunderstood the comments of other counsel, but I consider this to be a very serious and very sophisticated issue. So there.
We'll do that at 9 then?
So why don't we take that up at 9? I assume, Mr. Allman, we're talking about a relatively brief direct examination, 20 minutes or so.
Yes, actually, Mr. Neufeld will conduct it, and it should take no more than 20 minutes.
And I have to do that because if it's any longer, I have to deal with Professor McDonald, who's already been out here 3 times, and I assure the court that that's what we're talking about.
Okay.
Okay.
All right. All right, so tomorrow we'll take up Michelle Kessler first. We'll finish with Mr. McDonald. We'll play the Thano Paratus tape. And then if we haven't resolved the Tracy Savage issue yet, then we may run out of witnesses. But even if we have the Tracy Savage issue, well, I don't know how long that could take.
There is one other issue that Your Honor may be able to resolve today. In addition to the tape, we would like to present the Thano Paratus grand jury testimony. I don't know if that has been resolved yet.
No, that hasn't been offered formally to me. It's been mentioned, but nobody has cited, nobody has argued the admissibility or non-admissibility of the grand jury.
We can do that now.
All right.
Well,
No, we need to discuss one other matter. All right, let's finish Mr. Neufeld's. Do you need to go?
okay, then let's take care of this now then.
All right.
There are 2 items. One is, in front of the jury, Ms. Clark erroneously represented to this jury that the prosecution did not receive the notes of Professor McDonald from the April 2nd visit, an inspection of the socks. That was just flat out wrong. I'm not going to attribute a motive. I have no idea what was in her mind, but it's flat out incorrect. I have given the court a signed copy of an acknowledgement of receipt of discovery signed by Mr. Darden on July 17, 1995, in which, if you see, item number 3 on that sheet are the laboratory worksheets of Herbert McDonald dated 4/2/95. In fact, when the report was typed by a member of Mr. Cochran's office, she mistakenly said there were 2 pages of notes. When Mr. Darden looked at the notes, he observed that there were 3, and so he crossed out the 2 and he wrote in the 3. The 3 pages of notes were inspected again by Ms. Clark this afternoon. She has really, I think it's just completely inappropriately tried to prejudice Mr. Simpson by suggesting to this jury that the defense did something tricky in not turning over those notes. The notes were turned over. There's no question they were turned over. If by chance Mr. Darden didn't get them to Ms. Clark, or Ms. Clark may have misplaced them, I have no idea whether some inadvertent mishap occurred. But the bottom line is those notes, the very same notes that he just showed to Ms. Clark during the cross-examination, were turned over to Mr. Darden on July 17th, 1995, and he signed for them. And I believe, Your Honor, that at this point in time, what has to be done is this jury has to be told specifically that that was erroneous, that in fact those notes had been turned over on July 17th. No, it's July 17th. Those notes have been turned over on July 17th to Mr. Darden, and that he signed for them, and there is a receipt to prove it. I would ask for that. I would also ask, in addition, Your Honor, that because I think to make that kind of remark in front of the jury is incredibly reckless and is a reckless disregard for the truth when she should know better, that it warrants a monetary sanction as well from the court.
How much do you suggest?
I suggest $250, Your Honor, which was the last sanction she received. I also suggest a sanction, Your Honor, against Ms. Clark for having blurted out or attempted to blurt out that she was impeaching Professor McDonald with a case after, before direct examination, we set ground rules, Your Honor set ground rules, that she was not allowed to mention any cases at all without first approaching for a sidebar. That warning was reiterated this afternoon, just before I completed my direct examination and Ms. Clark began her cross-examination. And Your Honor affirmed that to her. She knew it darn well, and she ignored it, having been warned twice. And I think that also warrants a sanction, Your Honor, the amount of which I can leave up to the court. But I think...
Well, let me ask you this, Mr. Neufeld. If you recollect when you brought that matter up at the sidebar, and if you recollect, I'm the one who I think invited us over there in the first place, I indicated that I would take that matter under submission, the request for sanctions, once I saw the testimony, saw what it was, and determined how bad a violation it was.
Right.
And do you want to expound upon how bad a violation you felt that was and what the damage was to your client as a result of that?
Your Honor, the only point I would make is there was a suggestion, just by bringing up a case and her remark about, well, didn't you testify in this case that? And then she mentioned the name of the case. There was an inference that she was in fact asserting at that point that he was somehow testifying differently here in court than he had been in some other case. Number one, that's not true. Number two, you looked at the transcript, in fact, that she was referring to and saw that one had absolutely nothing to do with the other.
No, he said the same thing. He said it's tough to see blood on dark fabric is what he said.
Well, that's what I'm suggesting is by her then trying to say to him, isn't it the fact that you said something in this case, she didn't get a chance to actually get out what it was, because that's when you cut her off and asked for a sidebar. But the jury is left with the impression that either it's a more extreme statement or it's a different statement. It's something other than what the witness articulated from the witness stand. That's the whole point of trying to then refer to someone's testimony in another case. Otherwise, it wouldn't be brought up because it wouldn't be impeachment. That's how lawyers get to refer to other cases. The jury by this time is already primed because it's been a technique utilized by lawyers on both sides for impeaching witnesses, that when they hear the person start referring to some other case in your testimony, they believe they're about to hear impeaching contradictory testimony, which they didn't hear here. Granted, it is not the most substantial act of misconduct on the part of the prosecutor in this case. I'm not asking that the court treat it as such, but I do believe that in terms of your own desire to be even-handed and to maintain order here, that if the prosecutor had been warned twice not to do it and did it anyway, that some type of sanction is appropriate. I think, frankly, what she did vis-a-vis the notes is a far more serious matter, because there's no question in my mind that it does immediately and directly prejudice Mr. Simpson, and certainly Mr. Simpson's lawyers, by suggesting that we, by trickery, didn't turn over certain notes that we were required by law to turn over, when in fact they had been turned over.
Ms. Clark.
I've never seen law practiced this way, with lawyers asking for monetary sanctions against the other side. Never. Never. I am dismayed, and I'm embarrassed, and I'm ashamed of my profession when I see it practiced like this. I would never ask for a monetary sanction to be imposed against any member of defense counsel. Not one. That's for the court to do if the court deems it appropriate, but I would never ask for such a thing. And I think Mr. Neufeld should be ashamed of himself. Now, with respect to the discovery violation, Your Honor, I was deceived. The witness referred to notes. I've never seen any notes. I didn't know what he meant. When he said notes, what he actually meant was simply a document that introduced the fact that he had received the evidence at a certain point on a certain date, described what that evidence was, and then 2 pages of diagrams. He called those notes. I didn't know that. When I say notes, I think of written documentation like Dr. Lee made, detailing observations of what he saw. There was no such thing. Now, when he said notes, I was surprised, because I did not characterize what he had as notes. When he showed me what he had, I realized that the first page on which he had writing, I had never seen. Never seen. So as far as sanctions go, which goes to good faith or not, I had extremely good faith. I had never seen that before. Nevertheless, I didn't make a big deal about it, quite the contrary. What I did was to minimize it in front of the jury and point out the fact that those quote-unquote notes are nothing more than 2 diagrams and a description of the evidence and the date he received them, and he agreed that that was so. And we further pointed out that those quote-unquote notes made no characterizations of what he saw, did not detail his observations or his conclusions, or any observations that he made of the socks or anything that went on. So it is appropriately before the jury, accurately, exactly what that is. Talk about de minimis, that is very de minimis. Had the witness not characterized something as notes, which I would never have characterized in that manner, that exchange would never have occurred. I was taken by surprise. I had not seen that first page. I don't consider it a big deal now that I see what that first page is, and that is why I didn't ask to approach and ask for sanctions against counsel at that very moment. I could have. I could play the same game they're playing and pick, and every nitpicky little violation, I demand sanctions, and I demand they be put in jail, and I demand they be held in contempt. I don't do that. I don't need to do that. I can just practice law. I can just try my case without playing these little games here about nanny, 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 and neener, neener, and who's got the who's got the last sanction, who's going to pay money this time. This is sickening. You know what we've descended to in this case. That Mr. Neufeld stands before you because the witness characterized something as notes that no one else would so characterize, and because I'm taken by surprise by that, then question him about it because I see something I've never seen before, and stand before you and say that deserves monetary sanction. First of all, those words should never leave his mouth. Second of all, to make the mountain out of the molehill that this is ridiculous. But I was taken by surprise by the witness's characterization. The page I saw I'd never seen before. It has now been accurately assessed in front of the jury, and I don't know what kind of impact the defense would like to have, but I can guarantee this court that I will bring out with questioning from the witness that the 2 diagrams that he referred to I had seen before. And if the court wants me to further inquire of the witness whether or stipulate that that was turned over, that 1 page of document receipt, I've never seen it, but if the court wants me to indicate to the jury in some manner or stipulate that it was turned over on July 17th, I will do so. I don't have any problem with that, but a sanction, I mean, I think that we have really gotten into the outer limits here. With respect to the case that was cited, Your Honor, that case simply cited in support of what the witness was saying. And it was very clear I wasn't impeaching him. Because what my statement was, as I recall it, is that he said, yes, it's difficult to observe blood on dark clothing. And I said, yes, and didn't you so testify in the case of People versus Briggs? Totally consistent with what he said here. It was corroborative. And I wanted to discuss with him the circumstances of that case as by way of analogy. The court has precluded me from doing it so far, but I think it's relevant because he went to some lengths to try and visualize the blood for the jury because of the difficulty they would have in seeing it. And I think that's an important point to make. He didn't do that in this particular case, but it could have been done. In any case, that's all it was. It's corroborative of him, not impeaching of him at all. So what is the damage done there? There is none. I inadvertently forgot to approach, and had I intended to impeach the witness or do something damaging to his credibility with it, I think it would have occurred to me sooner to approach. However, in light of the fact that it was simply corroborative of what he was testifying to, I didn't see this as a harmful thing. And counsel concedes.
Do you recollect being directed on at least 2 occasions that if you were going to refer to a transcript, that before you did so, you were to ask to approach so that I could rule upon whether or not it could be used for that purpose. Do you
Yeah.
recollect that?
Yes, I do, Your Honor. I do. And I should have done that, and I simply forgot. And as the court recalls, I did do so on a subsequent occasion with respect to another case. But I forgot. I forgot. This has been a very contentious bit of testimony. There's been a lot to be concerned with, and a lot of argument back and forth about what the witness can testify to and what kind of questioning is going to be permitted. And so I forgot. I'm human.
All right, thank you, counsel.
Your Honor.
I'm sorry, hold on just a second. Mr. Darden, do you acknowledge that you received a copy of the 3 pages of Professor McDonald's worksheets that were dated April 2nd?
All that I can do is this, Your Honor. Whenever I'm given or provided discovery by the defense, I look at the documents, I count the pages. I don't know that, I don't recall what the notation is on this document.
The judge has the original. Here you go.
It's the 3rd item.
What I see is laboratory worksheets of Herbert McDonald, dated 4/2/95 and 3 pages. When I heard the witness say notes, I do recall having seen the notes. I didn't equate his use of the word notes with lab worksheets. But I count the pages and I look at the documents when I receive them from the defense, and so I certainly received a 3-page document relating to the witness's lab work as they related to the SOC. And I would indicate this as well. Once I receive these documents, I hand those documents to a law clerk. Okay, I don't keep them here in court. I turn them over to a law clerk immediately so that they can be documented as having been received upstairs. They're supposed to be circulated to Ms. Clark and myself. That does not always happen.
I don't know,
So,
Mr.
I don't know.
Darden, if I were a trial lawyer who had the job of cross-examining an expert witness from the other side, I would certainly want to see every note that was ever produced or anything that had been produced by way of discovery.
That's absolutely correct, and I agree with you 100% in that regard.
So
But
doesn't this sound to you mildly implausible?
Well, Judge, if you look at the 3 written on that paper, that I believe I'm the one that wrote that 3. I corrected the 2 pages, so obviously I'm paying close attention to that. But there are 40,000 pages of documents and transcripts and other things in this case. We assume that we get everything. I am often surprised to find additional things, like some stuff I found on Christian Reichart just Friday. I was amazed to find that. But it'd been up in our upstairs for weeks. It happens. I just don't think that every violation warrants this type of reaction from the defense or a reaction from the court. This is litigation, and these things happen. I've seen Mr. Neufeld approach witnesses on direct with documents he's never shown us. It happens. It just happens.
All right.
Just 2 very brief remarks, if I may, please.
2.
Okay. One is, she chose to make it an issue in front of the jury. She could have, at that moment, asked to approach a sidebar and didn't do that. And I think that exacerbates the whole problem.
Well, I have the transcript of the entire discussion, which goes on for all of 3 lines. It's not a huge discussion.
I understand that, but there was still, the suggestion was made in front of the jury, and it didn't have to happen that way.
That's correct.
And
I agree with you that the assertion that the notes had not been turned over is clear in the record and is incorrect. I agree with you 100%.
Okay. And the second thing, Your Honor, is, look, I agree that perhaps lawyers shouldn't be asking for monetary sanctions, but Ms. Clark's memory is somewhat failing her on this point, because she, on more than one occasion, had sidebars for the volume of my voice was suggesting that the court impose sanctions against me. And, Your Honor, I just feel that perhaps I reacted to her and what she did here because of the suggestions and her request for sanctions against me on earlier occasions. And she's right that it is sad that has to be the situation, but it is in that context that I made that remark, Your Honor. The only other thing I had to say, Your Honor, about the other aspect, which was the referring to the case, I think that the fact that it didn't impeach, and she knew it wouldn't impeach, makes the blurting out of the case all the more inappropriate. Thank you.
If you must.
Very briefly. This goes to the expert's opinion. and the fund of knowledge that he draws on for his expertise. And so prior casework that tends to corroborate or support his opinion is fair grist for the mill in cross-examination of an expert. He
But
has
the
this
problem
experience.
is, I don't care so much about that. I agree there are many things that you can cross-examine an expert about, his or her qualifications being a very broad area. I agree with that. I think you could have more obliquely approached that particular area regarding the difficulty of seeing blood spots on dark materials. That's not the issue. The issue is the court's direction to counsel that before any transcript was to be used, that you were to approach sidebar and ask for direction from the court. That's the problem. What I can't do at this point is, I've apparently used the wrong word search inquiry here, and I keep coming up with the wrong sites to the transcript. I want to review exactly what was said, the context in which it was done. At the very least, tomorrow I'm going to instruct the jurors that the inference that the notes had not been turned over was in fact incorrect, that they had in fact been turned over in a timely manner to the prosecution, and that the jury should disregard any negative inference to Mr. Simpson and his defense counsel. Secondly, I'll take the matter of monetary sanctions or other sanctions under advisement until I've had the opportunity to check the transcript. All right, anything else? Yes. Anything else?
Grand jury, you want to do that now?
Yes.
For the record, I never asked for Mr. Neufeld to be sanctioned because of the volume of his voice. The court will recall when that occurred.
I think that was my idea.
That's right.
Your Honor.
But in any event, let's not, no, this issue's over. This issue's over unless both of you want to get sanctioned without any recourse to the transcript. All right, grand jury testimony. Mr. Ullman.
I think we can handle this quite briefly, Your Honor. The defense trial brief dated July 20th with respect to the admissibility of the former testimony of Thano Paradas addressed the question of both the testimony before the preliminary hearing, of which we have a video of his testimony, and the testimony before the grand jury. The authority to use the grand jury testimony comes directly from Section 1291A1 of the Evidence Code. The former testimony exception really creates two exceptions. One, the former testimony is offered against the person who offered it in his own behalf at the prior proceeding, or, subsection 2, the party against whom the testimony is offered had the opportunity to cross-examine at the former proceeding. The first exception does not require that you even have an opportunity to cross-examine, because it is based on the theory that your presentation of the testimony as direct testimony is a substitute for your opportunity to cross-examine. And we cited the Salas case, which is really the leading case interpreting Section 1291. It's an opinion by Justice Bernard Jefferson, who is the author of the bench book on evidence. And in Salas, he was presented with a rather unique situation where the prosecution was offering preliminary hearing testimony that had been offered by the defense at the preliminary hearing. And he noted in the Salas opinion that under subdivision A1, a party's previous direct and redirect examination called by him on the prior occasion is justifiably considered to constitute an adequate substitute for such party's present right to cross-examine the declarant. So we didn't call the witness at the grand jury, the prosecution did. So their presentation of his testimony before the grand jury as direct testimony then justifies use of the 1291A1 exception to now offer that testimony against them.
Mr. Goldberg?
Well, in the Salas case, Your Honor, as I recall, I think the defense called the witness as their own at the preliminary hearing, and the prosecutor then wanted to use the transcript of the trial, and they held that it could, so it's slightly distinguishable, although I don't necessarily disagree with counsel's interpretation of the overall importance of the case or the evidence code per se, although we haven't found any cases that specifically say that grand jury hearings are admissible. Usually we've seen depositions introduced in cases where the declarant is unavailable or preliminary hearings. So while not conceding the issue, only because we don't have any dispositive case law, it doesn't appear that counsel's interpretation of the law that we do have is fundamentally unreasonable. What I would like to draw the court's attention to, however, on the issue of the admissibility of the transcript testimony is that previously the people filed a brief discussing if Thanoparatus were to be called, at the time that we thought that he might be called as a witness, the extent to which his statements concerning the amount of blood in the blood vial would be admissible. As the court will recall, when Greg Matheson was testifying on the same subject to trying to estimate the amount of blood in the blood vial, or that would have been consumed during various transactions, the court required the people to lay an extremely thorough foundation as to how those figures were arrived at. And in fact, he never really was allowed to testify as to approximately what quantities would have been used during certain transactions. The people could only get that testimony in by having him repeat those transactions during the evening, and then the morning following, repeating those transactions, testifying to the actual amount of blood that was used, as opposed to an estimation of the amount. So the court has, in essence, heard that even an expert witness cannot offer estimations as to small quantities of blood that were involved in particular transactions with the blood vial in question in this case. We feel that the same rulings are equally applicable with respect to Mr. Paratus, only even more so, because in fact there is no foundation. There is no foundation for how Mr. Paratus arrived at his estimation, and there is no foundation for how he calculated the amount of blood. In fact, we've talked to him since then, and he said that this was purely an estimate. So applying the same rules that the court applied to Mr. Matheson, that testimony should not be permitted.
Did
Now,
he testify it was approximately 8 milliliters? Is that what he testified?
well, at first he said approximately 8 milliliters, and then he was asked a clarifying question, what does he mean approximately 8? And he said between 7.9 and 8.1. Now, of course, as Your Honor knows, just by looking at the blood vial itself, it would be humanly impossible to, with that degree of precision, determine the difference between 7.9 and 8.1. So how he came up with those numbers seems to defy common sense when one looks at the fact that this is not a calibrated blood vial.
No, it's marked, my recollection is it's marked on the side of the tube, 10 ml, it's purple top.
The purple top tube is not calibrated.
No, I know it's not calibrated. I'm just saying that the label itself is, they're 5 ml purple tops and they're 10.
This is what's been, I don't know if it actually says 10 mLs on it, but everyone has been under the assumption that this is a 10 milliliter tube, and I believe Mr. Matheson testified to that.
Right.
He said that that was his long-time assumption. In fact, I think the tube actually has a capacity of 12 milliliters. I don't know if that's really all that significant in terms of the court's ruling here. But the point is that there is no adequate foundation and can be no adequate foundation for this kind of testimony. Now, as I'm sure Mr. Ullman will also agree, because I know that he's researched this part of the law as we have, even if a party did not make those substantive objections at the time of the preliminary hearing or grand jury, we do not waive them and can remake those objections at the time that the testimony is introduced. in the form of a transcript. The only objections that are waived are objections that go to the form of the testimony, but not any substantive ones, such as lack of foundation. An objection that something is leading or suggestive would be waived if not raised previously. But all of these substantive objections would remain. So if we could imagine Mr. Paradas testifying in court and being asked how much did you draw, we would object no foundation. That objection would be sustained in light of the court's rulings with regard to Greg Matheson. And I don't think it's an objection that the defense could ever overcome. So that portion of his testimony, if the defense wants to introduce the transcript testimony, should be stricken. And then the remainder read to the jury.
I save the court time on this. I think I can. This is completely misrepresenting and misleading as to what Thano Paradas already testified to. He's not relying on the test tube, right? He says, I drew 8 cc's. How did you know how much it was? He says, I just looked at the syringe, and it looked to be about 8 cc's. I saw the syringe in his office. The syringe is calibrated by cc's. Okay, that's how one does it. He didn't rely on looking at the test tube after all. He looked at the syringe. That's a sworn testimony at the preliminary hearing. That's a sworn testimony in the grand jury. He is not just an expert, he's a precipient witness. He's simply saying, I drew blood, I looked at the syringe, and it was 8 cc's. Was it exactly 8 cc's? No. It could have been as little as 7.9 or as much as 8.1. It comes in for that. And I would add one other point at this time, Your Honor.
Your Honor,
Mr.
do you have a one-attorney rule here?
Well, Mr. Ullman was actually addressing the admissibility of grand jury testimony. He then brought up a second issue, which is that none of it should come in, not because it's not grand jury testimony as opposed to preliminary hearing testimony, but because we can't lay a foundation. Since I was the person who was going to put on Mr. Paradas, as you may recall, and the person who had made the motion to strike their testimony.
All right, but I consider this to be a waiver of any other argument on the other issue. All right. Proceed.
Okay. They are suggesting that he has said something to them subsequently in time about his testimony in the preliminary hearing in the grand jury. Number one, when Mr. Goldberg had the argument last week on this issue, he actually suggested there were prior inconsistent statements. We know of no prior inconsistent statements made by Mr. Paradas which would contradict his sworn testimony at the preliminary hearing in the grand jury. More importantly, Your Honor, at this point in time, we have not received a single statement in discovery from the prosecution, a written statement of this witness, an interview with this witness, an audio tape of this witness, a videotape of this witness. We've received absolutely no discovery at all that contradicts what Thano Paradas said in sworn testimony both in the grand jury and at the preliminary hearing.
But here's the problem. They have, Mr. Paradas is on your witness list, and they have prepared, apparently, to impeach that testimony. Under the rules of discovery, since it's direct impeachment, they may not have to turn that over to you. All right, but...
So he was on their witness list, Your Honor. That's what I'm informed of.
Right.
Initially, they just chose not to call him.
He's on yours now.
Well, I understand, but if they had some statement from him before they rested their case, when he was still on their witness list, we should have received that statement, or it's a discovery violation.
All right, counsel, thank you for another entertaining afternoon.
Sorry.
Your Honor, may I?
No, I've heard enough, guys. Thank you. All right, I'd have previously, and if I haven't formally on the record, made a finding of unavailability of Mr. Paradas. We will allow his prior testimony from the preliminary hearing. Likewise, I believe that 1291 does also allow for the presentation of the grand jury testimony. As to the foundational objection that Mr. Paradas is not competent to testify to the amount of blood that was actually drawn, the court will overrule that objection. Paradas' testimony at the preliminary hearing was that he's been a jail nurse or a registered nurse for 20-odd years, that drawing of blood is a routine thing that he does, and that I assume that there'll be some other foundation later in the record, and I'll allow this testimony subject to that later foundation that calibrated syringes are used for the purposes of drawing the blood, that the purple top tubes are the type that are marked. My recollection of the photograph that I saw, it's marked 10 ml at the bottom of the tube is the type that was used in this particular case, so the objections are overruled. All right. All right, we'll be in recess 9 o'clock.